My lord, might have your lordship indulge and paying leave to move and public into litigation. A rape and murder of minor girl. If your lordship kindly give me leave.
You file it.
2
Why
PM,
leave?
but 2 PM, your lordship, they will destroy the evidence.
Why
2
leave?
PM,
Why leave should be granted? You file it, immediately it will be listed.
kindly take it up 2 PM. Because my lord, they,
You please file it, sir, please.
my lord, give the number. Then tomorrow, your lordship.
You please file it, sir. Please file.
My lord, may I be permitted to mention, my lord?
Yes.
An appeal is pending before your lordship. Earlier, this matter has been heard before the earlier bench. To kindly upgrade the matter because we are suffering for non-payment, my lord. Union of India has stopped payment to us. They are not payment. Kindly upgrade. I have already handed over the.
You give a mentioning slip telling that.
Yes, I have already handed over the papers, my lord.
Let us continue.
Kindly allow, my lord. This is the 709, my lord.
My lord, may I permit you to
Grateful,
mention one matter for upgradation, my lord? The tenure of the board is going to be expired on 9th June 2023, my
Please
lord.
give. You have explained.
Item number 285 of the monthly list.
No, have you mentioned the urgency?
Yes, my lord.
Well, I am telling for permitting me to file an appeal, memorandum of appeal without certified copy.
What is the urgency?
Urgency, my lord, the university has floated some tenders for building painting works. There was a blunder scam. Now the writ petitioner, after lapse of 6 years, have filed a writ petition before the learned single judge. And the learned single judge has directed the university to pay 50% of that amount of the third arraignment, which is 10th amount to.
What is the date of the order?
Date of the 17th, my lord. 2 days is the last date for making the payment.
All right, leave grant.
Well, may I have lordship leave to mention one matter, my lord? Urgency is this, my lord. I have stated in my mentioning slip, my lord, details of my urgency.
May I have your lordship's leave to mention a matter, my lord? I'm praying for the inclusion of the matter in your lordship's list. This is a contempt application arising out of the violation of a series of orders passed by the learned 13th additional district judge at Alipur. My lord, I had already mentioned before your lordship this matter
Already you
twice.
mentioned it. That slip is there.
Yes, my lord. But
You
the
give
matter,
hand over, let us see.
my lord, the matter is unfortunately not appearing in the list, my lord.
What to do? We have got. Let us see. Let us see.
My lord, upon notice, my lord, I'm mentioning
I'm grateful, my lord.
item number 505 of your lordship's monthly list.
Ah,
My lord, this matter relates to the custodial death of 4 under trials. My lord, in view of the violation of article,
You want upgradation.
my lord,
You please give, let us see. We have to arrange.
Lordship, may I be permitted?
my lord, grateful, my lord.
May I have your lordship's kind leave to mention one application for review, my lord? Matter is, my lord,
Application for?
review, my lord. Not your lordship's order. The point is, when the matter was heard, Honorable Justice Jyotirmoy Bhattacharya and Honorable Justice Rajyasree Bhardwaj were sitting, and that matter was heard and dismissed. And thereafter, I filed an application for review.
You please give a letter to the secretary.
My lord,
It has to be, a bench has to be constituted. You are telling.
My lord, may I have my lord's leave to mention this matter, my lord, for leave to file the memorandum of appeal without the certified copy. My lord, the order is dated 18th of April. My lord, section 14 application has been sought to be implemented. Kindly.
Lordship, may I be permitted to mention
Supreme.
one matter? Lordship, item number 740 of monthly list, this month for upgradation. Lordship, my application for electricity
Is all.
has been rejected. This court kindly upgrade this.
You please give the slip, let us. The Advocate General is here. Advocate General can, if he is free for some 5 minutes, he can come.
Well, definitely, I'll inform him.
Please call the list.
Appellate side daily list, item number 1.
And for the petitioner, my lord, why the matter has come under the heading to be mentioned, my lord, I don't understand, my lord.
We also don't
This
understand.
matter was heard by your lordship, my lord, on 11/4/2023. Lord, here, my lord, the Supreme Court has given liberty to file a review petition.
Lord, a writ petition was filed.
Under what distance, my lord, the matter has come, I do not understand.
No, it has come up because it was informed on the last occasion that Mr. Somiran Giri is representing the respondent number 9.
Yes.
But we find from the order sheet that Mr. Sujib Chakraborty
Yes.
and a host of other Yes. Lawyers represented.
Yes,
So
That's why,
That was the last official.
what is this? Who is representing the respondent number 9? Mr. Giri says, I am representing respondent number 9, and you are saying you are representing the respondent number 9.
And we not buy
It was
names.
correctly recorded in the order. Thereafter, on the mentioning of Mr. Giri, it was again an order was passed. For that, it is appearing as to be mentioned. Mr. Chakraborty, sort it out amongst yourselves. We are keeping it as to be mentioned tomorrow. Sort it out.
I'm
Ask
very,
Mr.
Lord,
Giri to appear
I'm very
tomorrow.
sorry, my lord, this inconvenience should
These
not have
things
happened.
you
Lord.
ought to have sorted out.
Lord,
In my instance, the matter was appeared before your lords.
Who is, who is now representing?
One thing, my lord, initially I, on behalf of the respondent number 9, appeared and the matter was disposed of. After that, my lord, the petitioner made an application for recalling the order and modification of the order. 2 copies of the application were served upon me. As a result, my lord, I compelled to appear before your lordship till 23rd, 2023. And my lord, in the meantime, my client issued a new wakalatnama, Mr. in favor of Mr. Orpadi Majumdar. I do not know. As a result,
Without taking no objection.
yes, no objection is there, my lord. Till date, the
Even a disposed
Sir,
of
I
matter,
don't want to get into this controversy, my lord. He should get that no objection, my lord. I am briefed, my lord, as to represent your
no,
lord.
no, you have to be very careful.
I have to. my lord,
When you enter
but
into a
Lord,
matter,
since the
which is-
PIL, perhaps since the PIL was disposed of, and this is an application, my lord, in the disposed of matter, perhaps a new Vokalatnama was issued. But it ought to have, my lord, no objection ought to have been taken.
Because a copy was served upon Mr. Giri.
But that is, that,
Appeared at one point
and
of
it
time.
was served on, and my lord, I'll ask my AOR, my lord, to
let
talk to
the
Mr.
9th
Giri.
respondent appear. We will direct who's the 9th respondent.
Kamal Dotto.
আপনার কি অথরিটি আছে অ্যাপিয়ার করার এখন? আপনি এখনো অ্যাপিয়ার করছেন?
এখন আমি জসাইকে বলতে এসেছি যে my lord, এই
আপনি
হয়েছে
এখন
ঘটনা।
করছেন কি? Lord, my lord need
My
not
lord,
not
this
call
is the
upon.
fact, my lord, it should be disposed of, my lord.
No, I'm not
No
appeal.
calling, my lord, respond, Kamal Dotto.
Yes.
The matter be here and now, disposed of matter. I retiring from this brief, my lord. That's all, my lord. Okay, we are the friends. We are the
Lord,
friends.
I have nothing to do, Lord. I have been asked to not appear in
No,
the.
no, my lord, no complication, my
Was
lord.
directed to appear under the heading to be mentioned. Upon mentioning by Mr. Giri, submitted that he has instructions to represent the respondent number 9, whereas the names of the learned advocates led by Mr. Shijib Chakraborty represented the respondent number 9 when the order was passed on
Lord, 11th April.
11th of April 2023. Today, both Mr. Chakraborty and Mr. Giri are present. Mr. Giri submits that he has retired from this matter, and Mr. Chakraborty is authorized to represent the respondent number 9. In view thereof, recording this fact, no further order need be passed.
Lord, I'm sorry, Lord. I
Forgetful matter.
was completely unaware of
Mr.
all this.
Chakraborty, you ought to have asked your advocate on record.
Yes, sir.
Take no objection before appearing.
I did not know, Lord.
Mr. Giri submitted that he is retiring.
He is
That's why
He
otherwise
is right, Lord. He is absolutely right.
you would have called the respondent number 9 to
Absolutely.
appear in person.
Absolutely, absolutely. But I was completely unaware of this, Lord. I'm sorry, Lord.
Item number 2.
My lord, here your lordship, my lord, had directed me to take steps for, my lord, the initiation of the work at Purva. My lord, we have prepared an action report. My lord, I was only requesting if this could lay over for 2 days because, my lord, we have sent letters. The legal remembrancer is the person who appoints both the public prosecutor and, my lord, these are not additional public prosecutors, these are associate public prosecutors. So they are also appointed by the legal remembrancer. My lord, it has been sent out, the district magistrate has also sent out letters that today we will be finding out, but still today, my lord, there was
No, remove both of them. Remove both of them.
my lord, I
They
think,
are unfit to hold this office.
my lord, why I'm saying, my lord, because today, my lord, till today, my lord, there was a, my lord, no adverse order decision, my lord. So, my lord, I was only submitting if it could lay back till tomorrow, my lord, so that we understand what's happening today.
Absolutely.
They have been assured, my lord, so that is.
I only want the court to function, my lord. I really
You
do
give a
not.
copy of this report
Yes,
so
yes,
that your
definitely.
friend can also.
Mr. Mitra, in the report.
And
it
we
has
have
been
already,
the
sorry.
Last paragraph, it has been said that accordingly, the normal functioning of the court is going to be restored. in that district on and from 24th of April. That is the last paragraph of the report.
And my
that
lord,
is today. That is today.
And my
Kindly
lord, we'll
keep
also
it
see
for
the.
tomorrow or day after.
Yes, yes, I have. My lord, also, my
Kindly
lord,
come
we
to
have
the
said,
last paragraph.
we have said that if required, all will be terminated. That's the second paragraph in the second two. We have told them, my lord.
Page 2.
One thing, my lord, on behalf of other
Tomorrow, day after. It's coming and
Day after tomorrow.
tomorrow.
My lord, day after tomorrow.
It's entirely for the, my lord, state to take action.
I think it will be, I mean, it's quite stern, I believe, my lord.
Yes.
on behalf of 11 additional public prosecutor of that district, my lord, conflict in between the PP and other, my lord, 30 additional public prosecutor. My lord, I am instructed to appear on behalf of them, on all additional public prosecutors. My
And
lord,
what is your stand?
my stand, my lord, already, my lord, we wrote a letter to the, my lord, district magistrate and also the, my lord, the honorable zonal judge, all the.
No, all of you function. If those two fellows are fighting, let them fight.
And they're not two, my lord.
No,
There
no,
is
no,
one and
we are ready to join, but never we obstructed, my lord, only pen down, my lord, and not only that, my
No,
lord.
no, if a public prosecutor participates in a pen down, he is fit to be removed. He is fit to be removed.
my lord, here, my lord,
Problem is that, my lord, what has happened, my lord?
but the public prosecutor has given letters saying that he wants to work and the others are stopping him. And the others say that we don't want you as the public prosecutor. That is being looked after by the legal remembrance.
Yes, my lord.
But it has gone straight on that everyone has to
No,
work.
please advise your clients properly.
Everyone has to work.
Some adverse orders will come, then nobody can save them.
If they have any,
Nobody can save
sorry.
them.
My lord, already, my lord,
This is not the way.
the honorable
No, he has taken an oath of office after he has become a lawyer. He has accepted the engagement given by the government as a public prosecutor. He owes a duty to the state. If suppose he is going to take sides and the court is not going to function, all these people will en masse be removed. En masse be removed. Please advise your client.
My lord,
properly.
that is what we have said.
Better sense prevail upon them.
The court should continue. If you have any dispute, the legal remembrance is looking into it. The public prosecutor says he wants to work, he's
You
being
don't have
prevented.
a vested right. You are
No one has a
functioning as
vested-
an additional public prosecutor, assistant public prosecutor, based on orders given by the government. Here and now, we will ask them to withdraw the order.
But I'm giving them only,
There is no vested right. Please advise your client properly.
I
Yes.
convey my client, my lord.
Yes,
I'm
yes.
very grateful. my lord.
They owe a duty to the public. They owe a duty to the public. If they fail to do that,
My lord,
nothing will deter this court from.
FIR was, criminal case was started.
All right, you face, once
It is
no, no.
my lord.
If a criminal case has been registered against you, your client, he is unfit to be a public prosecutor. He has to be immediately removed of that position. Let him get himself acquitted in the criminal proceedings, then
My
come.
lord, the public prosecutor, the main public prosecutor lodged complaint against us, my lord, first. But that FIR.
And you have lodged complaint, all of them, let them go home.
My lord, let them fight
Let them
outside
fight,
the court.
yes, let them
Let them
start the
fight
work.
outside the court. Let the court function.
My lord, we have said that if they don't function, we'll terminate. Let us look for 2 days, my
Yes.
lord, and then we'll en masse will do
Then
that.
what we can do is, you suspend all of them.
But I was only submitting, my lord, only 2
Let the
days left.
legal remembrancer consider that for interim suspension of all of them. And you appoint interim prosecutors, let the court function, let them sort out, go to the criminal court, go to the civil court, go to the street, do all sorts of things. Let them sort out their problem and then come back.
My lord, may I say this, my lord, maybe wait for 2 days. Let us see what happens today, because I think.
Unheard of, sir.
I know, my lord.
For 14 years, I have not heard that because of the fight between obviously, because couple of them are all political appointees, there will be brickbats will be there, but not even a single instance where a public prosecutor is refusing, suppose as a government pleader. Do you mean to say that you are very, very pally with all your friends? Difference of opinion does arise. Opinions does differ.
But I am afraid.
One person will say that it's not a fit case. You will say it's a fit case for appeal. You will say this ground should have been argued before the single bench.
But that is what I have been telling them, that if you have infights, you deal with it separately. You can't keep the court closed. So I think by today, my lord, it should be done. I'm keeping it, my lord, 2 days.
Or we can do one thing.
My
If
lord.
this is going to be the situation, the High Court will pass an order in the administrative side, transferring the jurisdiction of the bail court at least to the next nearby district. Then let us see what happens. The bar will come against you. The bar will come against
Whatever
you.
is falling from your lordship today, I'm sure it's going to go there. I think by
No,
day
it is
after
very
tomorrow
easy,
it
sir.
will be done.
It has been done. It has been
I
done.
don't know, my lord.
It
Yes,
has been done. And here also it has been done.
yes, yes.
And I have been a party to such orders. And then people will realize. People will realize. All your remand matters, extension,
Absolutely. my lord.
everything will go to the within 3 kilometers, 6 kilometers. There any other court, the next district will transfer it. And those lawyers will be very happy to receive those briefs.
But I'll also inform this to there. What fell from your lordship, I think that is good enough. By 2 days, I think it should.
No. Let us see.
And let's keep it day after tomorrow.
We have heard so and so. The learned government creator has filed a report. Dated 21st April 2023, signed by the legal remembrancer in charge, Government of West Bengal. The report is taken on record. At the request of the learned government creator, list the matter on Wednesday under the same caption. Same
Very
caption.
grateful to your lordship. Grateful.
Thank you.
Item number 3.
জানিয়ে দেবেন।
My lord, I have. What you say is correct.
My lord,
What you say is correct.
may I submit your lordship?
But who is the person who can enforce this?
My lord, it is the state government which is responsible for
No, which
enforcement.
department of the state government? See, this is a regular feature. Every day morning you can see them transporting the livestock or who are the respondents?
Well, the state of West Bengal.
State of West Bengal, at least some animal husbandry department or some department which has issued directives.
Well, it is my lord, I submit your lordship. In the state of Meghalaya also we filed similar petition. And in fact, my lord, the requirement is that as per the animal livestock market rules, the state is supposed to constitute a district animal welfare committee, as well as for each market animal welfare committee is supposed to be there. And then your lordship, for the transportation of the animals, it is which department, my lord, I am not very sure which department has to ensure that the poultries or any livestock has to be transported in accordance with the rule which is there since 1978, your lordship.
No, page 93 is the rules, amended.
Page 93, yes.
Under the rules, what does it say in the event of violation? What will be the?
But in the event of violation, my lord, the rule says that any animal which in fact any violation is done, or on any animal, if any cruelty is done, then my lord, till the pending investigation regarding the cruelty on the animal, that animal will be housed in an animal infirmary or an animal welfare center. My lord, but the difficulty is that all across the state, if the animals are being transported in a cruel animal, then I cannot suggest that all the animals be, my lord, seized and be kept in a animal welfare. So it is the responsibility of the state to ensure that the cruelty is not done to the animals while they are being transported. And in fact, while the animals are kept in the livestock market also for selling, there are detailed rules as to the manner in which they have to be kept. So those rules have to be observed. So the first step is that in every district there has to be a constitution of the district animal welfare committee, and for each market also there has to be an animal welfare committee. My lord, kindly have a look at those rules relating to the sale of the livestock market. My lord, they are on page. My lord, it starts from page 60. My lord, kindly have a look at page 61, Rule 3. Rule 3 of the Prevention of Cruelty to Animals, Regulation of Livestock Market Rules 2017.
Have you issued notice to the state?
Yes, Your Lordship, it was filed a long time back, so 2022, but it was not listed unfortunately. I can further submit. My lord, I can make a fresh,
We can give it to Mr. Chatterjee now.
There is another matter regarding to my lord horses. Your lordship remembers.
So this is different.
I have followed, my lord, I have followed. Lord, Home Department is carrying on. Lordship can give any direction on the Home Department to that they will function in coordination with the Animal Husbandry Department.
So both these departments have to be
My lord, my
made
lord.
party. We can so moto implead them.
Certainly, my lord.
Huh?
Certainly,
And
lordship.
who will be the appropriate, the principal secretary, is it? Additional chief secretary.
No, my lord, my lord will direct the Secretary Home Department and the Secretary Department of Animal Husbandry.
We have heard Mr. Vinay Sharaf, learned advocate for the petition, and Mr. Chatterjee, learned government counsel. In order to examine as to what directions are required to be given in this public interest led petition, the following authorities are so moto impleaded as the second and third respondent to the writ petition. And number one, the secretary to Government of West Bengal, Home Department. It is Nabana, no? Nabana, same. Nabana, Haura 71102. Number two, the secretary to the Government of West Bengal Animal Husbandry Department, Nabana, Haura 71102. Necessary correction be made in the cost title. So Chatterjee accepts notice for all the three respondents and seeks time to get instruction in the matter. Let a report be filed as to what are the steps which have been taken with regard to the issues which have been highlighted in this writ petition. List the matter in the monthly list of June.
Lord, I have requested for a copy from my
yes,
learned friend.
yes, I will do that. I will do
We are grateful, my lord.
that.
Item number 4.
My lord, I'm for the petitioner, Miss Rikamar Niyogi appearing for the petitioner. She is not well, my lord. I'm
He is not well.
please.
What is that? You tell us some facts.
My lord, I appear, my lord, for one of the respondent.
Hmm.
My lord, there is a adversarial litigation on the issue which has been adjudged against the council.
Hmm.
Against that matter, we have preferred an appeal. Your lordships have the determination to hear the appeals also.
Hmm.
We had mentioned the matter. There is a direction for the matter to come up on Wednesday. But I was praying this, if your lordship may kindly take up this matter along with that. Because according to me, subject to correction and lordship hearing all the parties, when there's an adversarial litigation in regard to my lord election of a statutory.
PIL on that.
Yes, yes. So kindly, my lord, take up both these together on Wednesday or Thursday, whichever day.
List this writ petition along with
Along with MAT 411 of 2023.
411 of 2020.
But I'm told, my lord, I'm sorry, my lord, there was a wrong communication from my side. I'm told your lordship directed the matters to appear on 4th. My appeal.
List along with SARS.
I'm grateful, lord.
Item number 5.
Yes.
Lord, may it please your lordship, my lord. Lord, if my lord kindly takes page 74, Lord, this is a notification, traffic notification issued by District Magistrate Murshidabad. Lord, under the active copy, press copy. Lord, kindly take this act. Under section 4.1 of this act. Now, Lord, in my understanding, if my lord sees 4.1 first, 4.1, kindly allow me to place it, Lord. Lord, we kindly take 4.1. The state government, Lord, Lord, may I place it, Lord? The state government or any authority appointed by the state government in this behalf may by order publish in the manner prescribed by the rules under this act prohibit the plying of any class of vehicles in the street or public place subject to such conditions as may be specified in the order. Then B, regulate traffic of all kinds in the street and public places and the use of driving vehicles in the street or public places with a view to preventing danger, obstruction, inconvenience to public. Regulate the conditions. Vehicles may remain standing in the street and public places and use the street. Then an order made under subsection 1 shall remain in force until this is the same is modified or rescinded by the authority making it or by the state government if the order has been made by an authority under the state government, other than the state government, provided that an order made by an authority other than the state government shall remain in force for such a period not exceeding 2 months. So, my lord, what they have done, not the main street, where not all the shops, not cloth shops and everything is situated, they made it one way. Now, my lord, if one crosses that road to come back, my lord, he has to travel 5-6 kilometers. But we are only praying that you make it both way traffic. Not that we made representations, but I'm praying for your lordship, not let that be considered in view of section 4(2) provides, so this cannot no longer be valid because this is issued by the district magistrate, not by the state government, and this has lost its force.
I think we have got better work to do.
I mean, only let them consider this, not because this is creating a lot of problem in the.
This writ petition has been filed
I have made a
by an
representation, Lord.
association called Berampur Cloth Merchant Welfare Association, which
Page
is stated to
46
be
is the
affiliated to FTO West Bengal and Murshidabad District Chamber of Commerce. The petitioner association challenges a notice issued by the district magistrate regulating the traffic in the particular area and accepting the request made by the Superintendent of Police Murshidabad via memo dated 31st August 2022 to maintain free flow of traffic and one-way traffic system on specified times. The petitioner places reliance on section 4 within bracket 1 of the West Bengal Traffic Regulation Act.
4(2) provides.
For section 4 of the West Bengal Traffic Regulation Act 1965 and submits that in terms of the proviso, such an order cannot be remain in force for a period not exceeding 2 months as may be specified in the order unless before the expiry of such period it is approved by the state government. In our considered view, the relief sought for in the writ petition cannot be granted for more than one reason. Firstly, it is up to the Superintendent of Police and the district magistrate to take note of the local situation and make necessary arrangements for the smooth flow of the traffic. Therefore, at the instance of a cloth merchants, this court cannot interfere with the order passed by the district magistrate or, for that matter, the recommendations made by the Superintendent of Police. Therefore, we find no grounds to entertain this writ petition. Dismissed. Next.
Lord, may our representation be considered?
Sorry, sir.
If we can go and convince them.
Sorry, sir.
Do not alter their decision.
Sorry, sir.
Chamber of Commerce was
Next.
heard.
Item number 6.
Deeply obliged.
My lord, I
My
beg
lord,
to appear
before-
on behalf of the petitioner in this matter.
Petitioner starts, I am representing the Howrah Municipal Corporation. We have just got the brief, your lordship. If
What is the prayer in the writ petition?
My lord, the matter relates to multi-crore scam in implementation of Nirmal Bangla mission, my lord. Now, my lord, what has happened? The civic body of Howrah, that is the Howrah Municipal Corporation, distributed some amounts of dustbins to the residents of the civic area. And my lord, they also constructed toilets worth several lakhs of rupees. Now, my lord, what has happened? The citizens have not received those waste bins, nor, my lord, those toilets which were constructed are functional, my lord. Entirely, the money has been siphoned off, my lord. That is the allegation in this instant public interest litigation, my lord. Now, my lord, my first prayer is that to call for an affidavit stating the numbers of residents to whom the waste bins have been distributed, my lord.
When was the scheme implemented?
My lord,
supposed to be implemented?
In the year 2020 or 21, my lord.
Now they will say the waste bins are broken off.
My lord, but they must be having the records, my lord, because I have also not received, nor many citizens have not received an affidavit containing the list of the citizens, the details of procurement.
You could have filed an application under the RTA Act.
My lord,
You some exercise.
my lord,
If you drop one email.
my lord,
And then this court is open, you
My lord,
throw a couple of
that is-
papers
my lord,
saying that this is
in
a
the-
public interest
my lord.
litigation, you call
My
for a
lord,
report.
that is one part, and my lord,
Then
the
you
other,
have to do some
lord.
research.
my lord,
You need to do some
lord.
research. Then suppose further probe leads
My
that
lord.
you are also a
My lord,
politically oriented
my
person
lord.
or an ex-chairman or a ex-ward member, then
My lord,
action
once
must be
I
taken
get
against
the
you.
data, my lord, this is one part, my
You
lord.
pursue your representation,
My lord.
you make proper inquiry and then come to this
My
court.
lord, one
We
more
are not
part is
here as
there,
a post office.
my lord.
80% of the PALs are all absolutely without any research, without anything. You send yeah, email 3 days, thereafter you file a report. We can't entertain.
My lord, another part is that I have annexed some photographs in annexure
No.
P1, my lord, in
This
page
writ
number
petition
21,
styled
my
as a
lord.
public interest litigation has been filed without making any research on the allegations made by the petitioner in the writ petition. By enclosing 4 photographs and 1 email communication, the petitioner cannot expect this court to conduct a roving inquiry. Therefore, at this juncture, we are not inclined to interfere with the inclined to entertain this writ petition. The same stands dismissed. However, it is also well open to the petitioner to avail other remedies open to him and collect sufficient material and thereafter proceed afresh in accordance with the law. Next.
Grateful.
My lord, I said will granted liberty to file a fresh application, and my lord, the respondent should consider my
you
RTA
advise your
application. My lord.
Don't
My lord, only
entertain
this
these
much
sort of-
liberty, my lord.
Next.
Grateful, lord.
Advocate General, something unusual and surprising has happened.
Lordships.
The chairman of the English Bazaar Municipality Malda has issued a demolition notice to the district and session judge Malda, stating that there is a building which has been constructed within the court complex, and it says building is situated under the jurisdiction of ward number 8 of this urban local body, whereas no sanction or permission for the said construction was accorded from this end. Whereas section 204 of the West Bengal Municipal Act has prohibited erection of any building without previous sanction of the Board of Councillors. Undersigned hereby issues notice under subsection so and so of section 218 upon your office. Any statement of facts in support of the erection may kindly be caused. There is a clear enactment of the Government Buildings Act. With these municipal laws don't apply. I have gathered information from the concerned district judge that in 2010, the government has granted approval. The chief architect has sanctioned the plan. The construction has been progressing at a very slow pace and it is now nearing completion. So what shall we do? I think we can issue a writ of quo warrant to this chairman, Mr. Kishenan Narayan Chowdhury. I am told that he is also an advocate, was practicing there. His family members are also practicing there. And we'll also issue a direction as to how much action he has taken within his municipality and how many buildings are unauthorized. This fellow has to be removed from office. Unheard of, sir, unheard of.
Lord, because even here, my lord, we've got the benefit of the Government Buildings Act, my lord, buildings coming up in the High Court as well. My lord, we've relied on
No,
those.
this is most
Absolutely.
unfortunate. Most unfortunate. Judicial Secretary has been informed. And he is a lawyer by himself, I am told. He's an elected chairman of the municipality. He's deemed to be aware of the proceedings. Therefore, before we thought we can do anything, we thought we should inform the learned Advocate General. And whatever at your end, you please,
My lord, I'll do, my lord.
you please see what can be done. If nothing can be done, then we'll
My lord,
deal
may
with
I take a
Yeah, you
copy? Obliged, your lord.
And there are, I'm told there are encroachments in and around the entire building complex. And the fire service department has said that we cannot grant permission because the fire engine cannot come. I'm told the encroachers are being rewarded and the chairman wants to put up a multi-storied shopping complex for them in the encroached property. And this man has got the audacity to issue a demolition notice to the district judge. Suppose we call for some report as to how many buildings within this municipal area are authorized or unauthorized. What will happen to it? Please give us a feedback 1 or 2 days.
Yes,
If he doesn't withdraw this notice,
I'll speak.
please, thank you very much.
My lord, maybe make a copy and hand this, give this
No,
back.
you can, yes, I want
Do
copy.
that, my lord. I'll
Yes.
make a copy and my lord.
Please, please, thank you.
Item number 7, Lordship. In this particular case, actually the cause of action has already been redressed by His Lordship's Honorable Justice Gangopadhyay on the earlier occasion, not before this court, but what I have asked for a CBI inquiry. But the same thing has already been directed. It is related to Oyanshil and Hooghly district. The same thing has already been directed by Justice Abhijit Gangopadhyay in WPA number 9979. Read with can 1 and
So direction has already been issued.
so let this case may be merged with that one.
That is before a single bench. No? We can do one thing. We will give permission for you to intervene in that writ petition. You implead yourself and intervene in that and support the petitioner's case.
Lordship.
This writ petition, styled as a public interest litigation, seeks for a direction upon the respondents to conduct an investigation by the Central Board of Investigation on the respondents on an alleged scam. It is submitted by the learned advocate for the petitioner that the relief sought for in this writ petition has already been granted in another writ petition by a learned single bench in WPA so and so number.
WPA 9979 of 2022.
Dated. Order date.
Order dated 21/4/2023.
2023 in respect of 2 of the districts. If such be the situation, we cannot entertain a public interest litigation on the same cause of action. Therefore, the writ petition stands disposed of, and if advised, the petitioner can seek for intervening in those proceedings to place facts which are in his possession. And the learned writ court is at liberty to consider such an application in accordance with law. Next.
Item number 8, and Lordship, one more indulgence. Lordship, it is read with can 1 of 2023 and can 2
You
of
write down and give it. You write in a slip and give it to the call.
Item number 8.
Item 8, Your Lordship, I am for the petitioner. Lordship, this matter is regarding the eviction of the street hawkers who are running their business at the roadside of Chaitanyapur Kukrahati Road at Purbo Medinipur district. They are running their business since 20 to 25 years now. Lordship, the only prayer is they are not against the development or the road widening, but the state government may take scheme and think about their resettlement and the compensation, because that is their only source of income. They have all the value.
They are hawkers on the road margin, is it?
Roadside street hawkers, Your Lordship, as all the hawkers run their business.
Whether any enactment has been in the state, it has been.
Before getting into that, Millard, first time, Millard, a public interest litigation where the people who are aggrieved is before Millards. Secondly, Millard, already a writ petition is pending, praying for the similar things which has been dealt by first Honorable Justice Shobhasachi Bhattacharya, Millard. There was an interim order. Interim order was vacated by Honorable Justice Moushumi Bhattacharya on the 24th of January 2023, Millard. Thereafter, this is the writ petition.
Same set, another set of people.
Another set of people, same cause of action, same documents.
But what they want is some rehabilitation.
Millard, for the purpose of rehabilitation, Millard, there already a writ petition is pending, Millard. If they have at all a cause there, Millard, they have to espouse that in a right forum, Millard.
What is that writ petition number?
Millard, the writ petition number is, Millard, WPA 8517 of 2022, Millard. Millard will kindly not take me amiss, Millard, as I have been informed about this.
So
in the
this
morning.
is pending for rehabilitation.
Millard, both for eviction and other purposes.
And in this, the interim order was vacated.
Interim order was vacated on the 24th, Millard. Honorable Justice Moushumi Bhattacharya was pleased to hold that only for the purpose which is there in the writ petition. Except for that, the petitioners will cooperate with the state authorities so that they can go ahead and continue the work of.
So the writ petition is still pending.
Then pending, Millard.
So the larger relief is resettlement, rehabilitation.
Milord, that is what I have been told, Milord, and that is what
You
the
implead yourself in
Lordship,
that.
on the only difference is, your Lordship, that has been filed by individual hawkers. Here, the petition is for all of them because all of them have
We
not
can't
yet been
know.
evicted, your Lordship.
So you know, you are aware of that writ petition.
Yeah.
This association or body of persons can seek for impleadment in that, and you try to get an order for rehabilitation. See, first of all, you are an encroacher.
Yes.
Even if you are there for 200 years,
Hmm.
it doesn't create any right. It is for the state government to consider your plight, whether you can be rehabilitated, etc. Whether there's a hawking committee which has been formed.
Yes,
Because hawkers need to be rehabilitated, because the local man, the common public, when they go back from office, they want to purchase small articles. They can't walk into big shopping malls, etc. So that's the reason. And all the state governments have been directed to enact a particular statute, or at least the rules pursuant to the central enactment. Are you aware of that enactment?
Yes, your Lordship, that enactment I am aware of, but
But
here
the rules
also-
have to be framed.
Yes, your Lordship.
And a hawking committee has to be formed in district wise. And suppose it is going to be a hindrance to the movement of traffic, public, or it is near a school, etc. The hawking committee can regulate. I can ask, you can remove and shift them to a particular locality. That's a large scale. So we will give you liberty to implead yourself in 851. Otherwise, it will be conflicting orders.
Yes, sir. Deeply aware.
By this writ petition, the petitioners seek for a direction upon the respondents not to evict them from the place where they are carrying on their hawking. It is submitted by the learned advocate for the respondent that identical relief was sought for by other hawkers in WPA 8517 of 2022. And in the said writ petition, there was initially an interim order which has been vacated by the court on 24th of April 2023. And the main writ petition is still pending. If such be the case, another set of hawkers cannot be, if such be the case, a writ petition styled as a public interest litigation by another set of hawkers cannot be entertained. Therefore, the writ petition is dismissed. However, this will not prevent the petitioners herein to seek for intervening in WPA 8517 of 2022, if they are so advised. If such an application is filed, it is up to the learned writ court to consider as to whether the petitioners should be permitted to intervene in the matter and to decide such application in accordance with the law. Next.
Item number 9.
But the number only would be 8517. Milord, perhaps this said 87. 8517. Milord, obliged.
My lord, in this matter, learned advocate Mr. Dilip Kumar Sinha is appearing, my lord. Due to acute diarrhea, my lord, he could not come to this court, my lord. Kindly make it not today and tomorrow, my lord.
What happened to his representation? He says some boundary wall is constructed.
My lord, it is to the Pradhan. I cannot represent. Kindly direct him to consider it.
By this writ petition, the petitioner seeks for a direction upon the second respondent to take a decision in the Panchayat board as to whether the boundary wall is constructed within the purview of the Panchayat Act 1973 and the rules framed thereunder. And in case it is not in accordance with the provisions of the Act, to take action for demolition of the unauthorized boundary wall. In this regard, the petitioner has submitted a representation on 13th March 2023. Page number 17.
No, it's not a representation. 13 March is the answer to the representation is by a clerk, not by petitioner. Representation is by a clerk. secretary of a club, not by the petitioner. This is absolutely a private dispute, my lord, sought to be brought under public interest.
Separate representation dated 13/3/2023. It is on going through the affidavit filed in support of the writ petition, we find that a private dispute is now sought to be made as a public interest litigation. The representation is also not by the petitioner, but by a private club. Therefore, the relief sought for in this writ petition cannot be granted. Same is dismissed. However, the aggrieved person is entitled to seek appropriate remedy in accordance with the law. Next.
The first portion of the dictation that your lordship, judgment that your representation by the respondent number 2, that should be struck.
It is not representation by the respondent, by a private club.
Otherwise, my lord, there would be.
Next.
Item number 10.
Hawker Sangram Committee.
In this matter. My lord, this is with regard to rehabilitation of hawkers. My lord, in the New Town Kolkata Development Authority area, my lord, what has happened, my lord? They are trying to reallocate some hawkers, but through.
But they have virtually come into the road. They have encroached. As I passed through that side, they have come into the pavement. They have come into the service road. Nothing can.
My lord, what has happened, my lord, since
they are taking law into their hands.
That
now it is a what is Hawker's regime? Hawker's regime.
That your lordship will consider definitely, my lord. What I am on is, my lord.
No, nothing.
The process of
you pursue your matter before the appropriate authority. We can't issue because enough is enough.
My lord, kindly grants me just a minute of time, my lord. What has happened? They are, my lord, rehabilitating hawkers, reallocating them to a different place. But that is being done through a process of lottery, my lord, which is dehouse the law.
No, forget
lord,
it. Don't participate in the lottery.
My lord,
you are an encroacher, sir. What is your person who claims that equity needs to be done? You need to act in equity. There is some scheme which has been formulated under the provisions of
rules
the
have been framed by the West Bengal government. My lord, scheme has been formulated, my lord, under this central statute. My lord, there has to be a town vending committee, my lord, constituted. The town vending committee, my lord, will conduct a digital survey. They will declare a zone to be a non-vending zone, and if a hawker is found in the non-vending zone, he will be evicted, my lord. That the law provides. My lord, what has
if he is hawking in a service road, it is obviously a non-vending zone.
My lord, that is the reason since the last 5 years we have been, my lord, repeatedly pleading that let the town vending committee
let the individual hawkers. Who are you? You are an association.
My lord, yes, we are an association.
We don't know who are your members. A list of members have not been given. Where you are hawking, nobody knows. Let the individual hawker approach the concerned authority or the writ court with this individual grievance.
My lord, only one thing, my lord, till
this
that process, my lord, till that process, this illegal process may be, my lord,
this
may be
public
injuncted.
interest litigation.
Kindly.
Sorry, sir.
My lord, kindly give me, kindly.
We can grant you permission to withdraw so that your individual members can agitate.
My lord, they have a right, my lord, but my lord, my only thing is through lottery, my lord, allotment cannot be given. It has to be by the town vending committee, my lord.
The committee cannot participate in the lottery. You are not an aggrieved person. Let the aggrieved person come, because there are a lot of ghosts. We do not know who is the hawker.
My lord, that has to be, my lord, identified by the town vending committee. This is what I'm praying for.
6 years. I've been heading a division bench on this issue. 6 years.
Your lordship knows
only
about
one option: you withdraw or we dismiss. After some arguments, the learned advocate for the petitioner sought permission to withdraw this writ petition with liberty to the individual hawkers to approach the ventilate the grievance in accordance with law. Writ petition dismissed as withdrawn with liberty sought for is granted. Next.
We are grateful, my lord.
Item number 11.
Lord, I have served the copy.
Well, I am for the respondent number 8.
Lord, only the respondent number 2, my lord, could not be served as yet. Lord, that is as far.
Absolutely a private.
The report of the status report.
What is the order passed by the executive officer, Rishra Municipality?
Lord, there was a previous order of this honorable court, and in terms of the order of this honorable court, my lord, at page 75, Lord, impugned order has been challenged Lord, 170 square feet, Lord, tank has been filled up. Lord, in the revenue record, it is a tank. And Lord, the
72.
finding is it is a tank. Finding of the authority that it is a tank, it has been filled up illegally. But still then restoration order has not been passed. That is my grievance. Lordship, kindly come to at page 75.
71.
Lord, page 11 at page 78. That as per information derived from BL and LRO, Sirampur, Uttarpara, Hugli, as well as partition deed submitted by petitioner and private respondent, it is established CS and RS dag number 7003, LR dag number so and so is recorded as pond in the settlement record BL and LRO. Now, Lord, your Lordship, kindly come to, Lord, he is the authority, Lord, at page 76, Lord, Roman II. Lord, as per notification, Lord Municipal Commissioner,
No,
Commissioner,
sir, one
Executive
page,
Officer.
page 81, the executive officer says somebody has converted it. Huh? And
Yes. Nature and character of the
as well
building
as the
change.
co-trustees of Sri Net, not a so-and-so Jew estate, including the applicant.
Lord, that is wrong, false, because we have been making, Lord, objection, Lord, 2014, and we filed a writ petition preventing them not to make any, not to fill up the tank. And what they did, my Lord, they filled up the tank, they raised construction in the municipal area on the filled up tank and collected rent from the tenants by the private respondents. Total illegal. There was no sanction plan.
Who appears for the Rishra municipality?
First of all, the Administrator General of Government of West Bengal maybe made a party respondent here. Because this trust has been dissolved long back in the year 1956 by a suit. The Administrator General Government of West Bengal has taken charge of it by dint of that order.
Correct, sir. No,
This private,
no, the
I'm
finding
coming. This respondent number 8, he has entrusted to run the trust. This is 5th round of litigation. It's an 80, 90 years old property. On affidavit, in other proceeding, we have stated that with the span of time, 71, with the span of time, the water body became a bit shorter. We have given affidavit to that effect in other proceeding also, that let the BLRO come, let any authority come, intervene, dig the tank, but their interference is should be restricted because they claiming themselves to be the trustee, which they are not.
No.
Trying to intervene in the matter with the promoter so that they can make construction in other portions.
No.
Your Lordship kindly sees. On affidavit, I have stated in this sees, this is filled up tank. With the span of time, obviously, this has become a bit shorter. On affidavit, we have stated in other proceedings.
No, it is for the municipality.
Absolutely a private dispute.
Wait. The executive officer has passed an order. He will implement the order. That's
yes. We are going, this order, we are aware of this order, we are going to challenge it. But their interference, they are no one. Their interference is.
We will eschew them.
Yes, I have approached before the Administrator General. Please take over charge of the property. Please release me. I just want the deity to be take care of.
But suppose
by any way, this way or other way, they are trying to get into the property with the promoters.
They will not.
Lord,
for the municipality.
Administrator General, Administrator General,
That's your
he
problem.
is the
That's your
trusted.
I pay for the state, my lord. But absolutely,
Who's appearing for the Rishra municipality?
I don't know, my lord. They are not represented.
You can't appear.
No, my lord.
You implement this order. As long as this order remains, the municipality has to implement the order.
Only one thing, we have a right, because there is an observation that we have filled it up. Obviously, we have not. Your Lordship kindly sees the pictures one. And on affidavit,
we is not filled up. Lord, immaterial, my Lord, according to 10. Lord, according to 17.
On affidavit, we have stated that with the span, your Lordship kindly sees the photographs once.
Lord, Inland Fisheries Act. Lord, as per observation that has been given
on affidavit, we have stated
Lord,
that
tank
with
is
the
liable to
span
be
of
restored.
time, it has become shorter.
Tank is liable
We
to
have
be restored.
invited the authority, please come and restore it. This is also our prayer. On affidavit, we have stated it. Your Lordship kindly sees.
They said
They just try. They just want to intervene. That is their purpose.
Nobody shall be allowed to obstruct.
But may I say this, Milord?
My lord, only
Since the Rishabh municipality is not being represented, Milord will kindly direct another date, Milord, when they, because I do not
Nothing,
have
they
any
need to.
instructions.
Otherwise, he is also colluding.
Milord, I have no instructions for the Rishabh.
my lord, only
That is the
Why do you want to quash this order?
The executive officer who is the fisheries authority as per notification. Because, my lord, in the impugned order, it has been said, he as per notification, your lordship kindly come to page 78. 78, my lord, will clear the scenario, my lord.
my lord, only keep the
Page, my lord, 77. Sorry, my lord, page 76.
What is
Lord,
this?
as per notification, competent authority under the Act, municipal commissioner, executive officer. Page 76.
Page 76, where are you reading?
Lord, from the impugned order.
Which paragraph of?
Lord, first paragraph, second part.
Hereby authorize the following municipal.
The following authorities to be the competent authorities under the said Act.
Correct.
Now, Lord, municipal commissioner, executive officer of the municipal corporation.
Yes.
Now, Lord, order passed by the executive officer of the municipal corporation. He is the authority.
That is correct. He has said, if you come to page number 79. Page 79.
Page 79, Lordship.
Last paragraph.
Last paragraph.
Perusing the above facts and circumstances, it is established that as per section 17 to C 10A3, it's a bar to conversion of water areas, etc. for other use, stating that as per clause so and so, any such order. In the instant case, the appellant private respondent, another trustee subdivided the water body between them.
This is
you are also party to the scam.
Lord, this is perverse finding. That is why we have annexed the partition plan. Partition plan, my lord, entire Lord tank has been kept Ejmal. That was not partition.
He is not. By this public
Lord,
interest
I'll
litigation,
want
the
more
petitioner
intelligence,
has
my lord.
challenged an order passed by the executive officer, Rishabh municipality, dated 20th September 2022, which is in respect of a water body. The allegation of the petitioner is that the water body has been encroached by the private respondents. It has been filled up, construction has been put up, and there is also a partition being made of the property. In page 5 of the order passed by the executive officer, dated 20th September 2022, it is accepted by the said authority that as per section 17 within bracket 2 within bracket small c and 10 within bracket small a within bracket 3 i's of the Fisheries Act, of the Inland Fisheries Act, West Bengal Inland Fisheries Act 1984, there is a bar to conversion of water areas, etc. In spite of such an observation, the ultimate direction issued in the order dated 20th September 2022 does not include a direction for restoring the water body to its original state. The private respondent, the eighth respondent, the learned advocate for the eighth respondent submitted that the eighth respondent has been kept in charge by of a trust to manage the properties, but the trust has been dissolved long back, and the Administrator General should take over the trust. In the impugned order dated 20th September 2022, there is an allegation that the writ petitioner applicant is also a party to such illegal conversion. This allegation is emphatically denied by the writ petitioner. It is a submission of the learned advocate for the eighth respondent that on affidavit, the eighth respondent has stated that if there is any encroachment or filling up of a pond area, the same can be inspected and restored to the original position. In the light of the observations made by the executive officer, Rishabh municipality, dated 20th September 2022, it goes without saying that even if the pond is not in existence as on date, if it has been registered as a water body in the revenue records and the conversion is unauthorized and illegal, It is for the executive officer of the municipality to take action in accordance with the law so that the pond is restored. Accordingly, with the present, accordingly, writ petition is disposed of by directing the fifth respondent to issue notice to the petitioner as well as to the private respondents, conduct an inspection of the area, and if it is found that a water body / pond has been illegally converted, steps should be taken to restore the same to its original position. The above direction be complied with within a period of 2 months from the date of receipt of the server copy of this order. Instead of that, executive officer is a commissioner of the.
Within a period of, my lord, certain time,
My lord,
within
only
1 month or 2
months,
months.
2 months.
2 months.
Only two things, my lord.
Lord,
Interference of this present petitioner, my lord.
nobody can interfere. Not
And, my
only
lord, and the
petitioner.
second thing, my lord, and second
Nobody
thing, my lord,
can be allowed
let
to
a scope be
interfere.
open for me to challenge the
Nobody,
order
my lord,
because, my lord,
we are complaining.
inter allegation is against me, but that I have filled it up when I have not, because
They are
other consequences is there, my lord.
They
If it is alleged against me,
The commissioner, before taking action, shall issue notices to the petitioner as well as the private respondent and give them an opportunity to make the their submissions and place records in their possession, and thereafter decide the matter in accordance with it. Next.
And blood the affidavit of service file we kept to the record.
The affidavit of service kept on record. Next.
Item number 12.
Candidates were selected for the post of sub-overseer under Kolkata Corporation, Your Lordship. It transpires from the list of successful candidates that candidates of a certain place only were
Service matter
selected.
PIL.
It fails the test of probability, Your Lordship.
The writ petition filed as a public interest writ petition for litigation concerns a service matter. Hence, PIL cannot be entertained, dismissed. Next. Next.
Item number 13.
13. Lord, I beg paper for the respondent number 6. Your Lordship, I appear for the petitioner. When this matter was Your Lordship filed, it was mentioned before Your Lordship, and Your Lordship had stated that these are mere apprehension, as a result of which it was not upgraded. And ultimately, the speeches were given, and the ED is also over, Your Lordship. Actually,
next year you come in advance.
Your Lordship, it's my humble prayer, Your Lordship, that those points be mentioned in the form of a supplementary affidavit, Your Lordship. But these are all, my lord, public interest litigation, not. My lord,
We have heard so and so.
political interest litigation.
Admittedly, the relief sought for in the writ petition does not any longer survive. Hence dismissed. Next.
Item number 14.
14, my lord, I am for the petitioner.
14.
I beg to appear for union opinion.
Last occasion, Your Lordship directed to file a supplementary affidavit, my lord. Disclose all the
You have filed
subsequent facts. Yes, my lord, subsequent affidavit, my lord, the supplementary affidavit I have prepared, but not yet it has affirmed, my lord.
At the request of the learned
My lord, may
advocate
I-
for the
On the last occasion, it was desire of your lordship. The lordship was pleased to direct the petitioner to get information whether she want to pursue with this application or she want to file afresh by disclosing everything. That was the observation of your lordship. Because
But
there are
she wanted to file a supplementary affidavit.
I'll let a copy of that.
Time granted for filing the supplementary affidavit is extended by 3 weeks from date. This affidavit be served on the learned advocates for the respondent. List after 4 weeks, you give a date. Next.
Item number 15.
15 to 18, 19 is the same identical matter. I'm for the response 14. The Vikas Ranjan Bhattacharya is appearing for the petition.
This is that community certificate matter. No.
No, this is regarding, my lord, PSC challenging the appointment in the of a officer, WBCS officer in PSC and other. There are 4 matters that in the first one I am appearing for the private respondent. Their allegation that I've been selected not in a proper manner. Mr. Bhattacharya is at the last
only short
occasion.
pass over, lordship. He's before on his legs, lordship. Only short pass over, lordship.
Today Passover is difficult.
There are 4 matters in the first one, and
What has been challenged?
Yes, I said. But in the first matter, there's a various challenges. One of the challenges is that my client has not been selected in the result of the preliminary examination of the WBCS examination. And his name was subsequently included by Courageanum. That is the challenge of my appointment.
What is the post?
This is executive West Bengal Civil Service Executive Officer and it's a preliminary. There's two preliminary exams.
There is an admission already by the Public Service Commission that he has not passed the preliminary examination. Kindly see.
Which one yours?
No, Mr. Bhattacharya,
19.
Mr. Bhattacharya is not here. We'll have it some other day
My lord.
Or my lord.
at the request of the learned advocate for the petitioner. You give a date, sir, sometime.
Next week.
16 to 15, 16, 17, 18.
Tomorrow, my
He will give a date. Next.
next circuit bench. I may be there.
Item number
19.
It's my lord. My lord.
Item number 19, my lord. I have the privilege, my lord, to assist this court as a special officer.
I am for
My
the
lord,
petitioner, my lord.
kindly takes up my last report, 11th report, my lord. I have annexed everything. Lordship may kindly takes up the 11th report first. My lord, first annexure would be my appointment as a special officer. This is with regard to, my lord, a road. My lord, Lordship knows Golden Quadrilateral was, my lord, introduced in 2000. My lord, 2006 onwards, we are trying to, my lord, build 4-lane highway from here till Assam Bengal border, which connects the northeast. My lord, kindly takes up once my 11th report, my lord. I have given, my lord, kindly takes up that, my lord. Lordship, it will be easier for me, my lord. I was appointed, my lord, as the special officer on, my lord, 8th March 2019. Kindly takes up the order appointing me as a special officer. Excellent. For the purpose of ensuring effective implementation of the entire 4-laning project of NH 34, Barasat to Dalkola, NH 31 between Dalkola to Ghoshpukur, NH 31D from Ghoshpukur to Salsalawari, and NH 31C from Salsalawari to Assam Bengal border. This court is of the view that a special officer is required to be appointed for better coordination. We therefore appoint Mr. Hon'ble, a practicing advocate of this court, to be the special officer for the purpose of ensuring effective implementation of the entire project indicated herein below. Remuneration, my lord, I have refused remuneration. Now, my lord, Lordship may kindly takes up now the next page. Kindly comes to page 12. These are the, my lord, maps. Kindly comes to page 12 of my, my lord, report. This is the map. Well, I have indicated the part from where the road goes. Now kindly comes to page 13. This is a blown up, my lord, map. Kindly sees from Kolkata. This is from Kolkata, kindly sees, and it is ending at Salsalawari. I have also marked that place. This is going through, kindly sees, the chicken neck. This is the chicken neck of India. This is very important place. I have also documents that something has to be done here also. So this is my scope. Next page is, my lord, the inline drawing, which they call, which shows what are the projects which were required to be done in this entire thing. Page 14 and page 15. Now, my lord, what I do is that, my lord, I go and conduct, my lord, meetings with the district administration, the national highways, and the other, my lord, stakeholders in the districts itself, so that, my lord, I can record what are the difficulties that they are facing and try to seek out, my lord, the remedies. Now, my lord, I have been doing this in different districts. Orders have been passed from time to time with regard to districts. My lord, I only bring to the honorable court the issues that I cannot, my lord, settle or handle. Now, my lord, one of the issues that my lord, part which is very important, which is, my lord, important to everyone here, my lord, at least from Calcutta, is the part from where this Barasat to Krishnanagar. My lord, this was, my lord, this entire project was, my lord, initiated and started pursuant to orders of this court. My lord, kindly comes to, I have given a short, my lord, kindly comes to page 40. I have given a short recital there. This is a meeting which was convened by me in presence of the project director and the general manager of NTPC, because one of the issues that we are facing here is shortage of fly ash, supply of fly ash. Now, my lord, kindly, my lord, may I just place paragraph, my lord, 3. My lord, paragraph, second paragraph and the third paragraph. The reason for calling the current meeting is for ensuring execution of four laning work from Barasat to Krishnanagar NH 34 having length of 66 and such and such. Background of this project that the decision for execution of the same was adopted sometimes in 2006, my lord, and the land acquisition process was initially 2009. The work was initially awarded to an agency which failed to construct the same and was terminated in 2016. The Honorable Division Bench in this matter, my lord, while considering the public interest litigation, was pleased to express its anguish and dissatisfaction about the progress of four laning as recorded in the order dated 5/7/2019 and thereafter the tender dated 25/7/2019 was floated, which is now being executed by KCC Buildcon. Next page, my lord. The relevant notification and rules requiring execution of the work by utilizing fly ash sourced from thermal power is discussed. The general manager ADM has apprised the house that previously the supply of pond ash was entrusted to NHI upon execution of a memorandum of understanding which the NHI could themselves lift the required amount of fly ash from the site and the cost was reimbursed by NTPC. This arrangement was continuing till 2021. In the meantime, in view of the guidelines issued by the Ministry of Power and Central Electricity Regulatory Commission, the procedure was changed from entering into a memorandum of understanding with NHI to float independent tenders by the NTPC, inviting bids from transporters to supply pond ash to the NHI or whatever is required. However, as the ash lifted by the successful transporter in the aforesaid bid system was not sufficient, NHI approached NTPC and NTPC as a special case, considering in view of the larger interest of the project and the pending public interest litigation as above, as a special case, NTPC extended, my lord, kindly excuse this, my lord, mistake, my lord, I dictate the minutes there itself and get it signed. So therefore, my lord, kindly excuse me this, my lord. With the NTPC, as a special case, NTPC entered into memorandum of understanding with the NHI for Barasat Krishnanagar and as well as Raniganj Dalkola to expedite the supply of ash. The earlier signed memorandum of understanding in respect of Barasat Krishnanagar has already has been already executed and ended. In view thereof, NTPC and NHA are in process of executing fresh memorandum of understanding for supply of 7.83 lakh cubic meter to the Krishnanagar project, which would be helping the project. Next is the project director NHI has brought to the notice of the house that the supply of 2.2 LCM of fly ash is required to be supplied by the successful contractor through competitive bidding. It has also been pointed out by the representatives of the NTPC that, my lord, they have supplied 75 LCM of fly ash to the project.
Now what is the position?
Now what happened is that this memorandum of understanding was entered. That memorandum of understanding I have also brought on record, that is from page 45 onwards. Now, my lord, here I should also draw your lordship's kind attention.
No, what are the directions which you now require?
Now, my lord, what direction is that even in spite of, my lord, this, and my lord, I can draw your lordship's kind attention to the previous orders also, where this honorable court was pleased to direct that the NTPC should continue supply of fly ash no matter whatever rectipism is there, and the general manager NTPC was directed to ensure that is very natural.
No, he has agreed in that meeting.
Yes, that is. Now, my lord, what happened is that now, my lord, on 7th of last month, my lord, when I went, I noticed, my lord, the progress is not, my lord, satisfactory. From one part, it has progressed, but other part, there are 3 parts, my lord, where I noticed that at Hodinghata Mode, Chagda and Ranaghat, the notice was not satisfactory. Now, my lord, I inquired about that. The National Highway has said that they are not getting fly ash even after this memorandum of understanding has been, my lord, entered. And, my lord, the person to whom what happened is that this is not on record. This I am telling to your lordship since I was there in the meeting convening. What happens is that the competitive bidders in the tendering process, my lord, the rates were so low that no one was interested. So therefore, what happened is that the concessionaire, the KCC Buildcon, who is executing the project, has taken up upon itself to carry the fly ash from NTPC to the project. Now, my lord, what happens is that they are doing it at whatever cost, my lord, that is been entered, which is the lowest cost. But my lord, if that is how, my lord, the burden has been shifted by the NTPC to the NHI. Now, my lord, my submission before your lordship is good, bad, indifferent. In respect of this, there should not be any delay in supply of fly ash because monsoons are, my lord, coming. My lord, moment the monsoons come, my lord, the entire work, it happens. I've been doing this work from 2019 onwards. I know on the next date of hearing onwards, it will be said that since the monsoons are there, we are not being able to do the work. So therefore, my lord, as of today, my lord, I'll be praying in respect of this stretch. I'll be going to the next stretch also. There are other issues that I'll be bringing to your lordships district wise. Now, my lord, in this stage, my lord, kindly comes to my report. This I have, my lord, said in paragraph 5. Page 4, last part.
But in your report, you say they have challenged it before the High Court.
No
of
more.
Delhi.
That is Alipurduar. That I'll come, my lord. There are 8-9 districts I am monitoring, my lord. Kindly comes to page 3. Page 3 is Nodia. Page 3 of the report. Now, all what I have shown before your lordship, I have said, and kindly comes to page 4, last paragraph. However, during the field visit of the London Special Officer held on such and such, it was informed that the project that adequate quantity of fly ash was still not being made available after execution of the contract. It was observed that the work of four-laning after incomplete Shantipur bypass to Krishnagar has been proceeded and completed, and it is awarding the finishing works. However, the progress in the remaining part of Horingata to Shantipur, which includes Ranaghat, Chakda, have not been completed, save and except the erection of structures. This part is suffering in view of the deficiency of fly ash.
Now, who appears for NTPC?
NTPC, my lord, Mr. Mondal appears. He is for the NHI.
This is the report, my lord.
I am appearing on behalf of the NHI.
The Krishnagar from Krishnagar to Farak is the far distance of 300 kilometers, my lord. Every day, my lord, 187 trucks has been loaded. But nearer the Bandel thermal power is there, my lord, only 10 kilometers. They may be added the Bandel thermal power, my lord. The difficulty is, lord, I have no grievance to anybody. We are ready to supply the fire.
No, the other thermal plant where you are saying it is nearby.
Yes.
Is it a Government of India enterprise or a private?
That is a state government.
Bandel thermal power is maintained by the state of West Bengal. And as far as NTPC is concerned,
So why can't the fly ash be procured from there?
My lord,
May I
this
just
is a policy, my lord. The notification says that any project within 300 kilometers of any thermal power plant, they have to take fly ash from the thermal power plant. Now, my lord, the NHI has decided that they will take it for NTPC. Why? Because the other part, which is from Uttar Dinajpur, that is Farakka project, Farakka to Uttar Dinajpur, Raiganj, more towards North Bengal, this NTPC is nearer. So therefore, they had approached this NTPC for both the parts. Now, my lord, to go to a different entity altogether, I don't think that will be, my lord, that will again, my lord, delay the thing.
Raiganj is 100 kilometers.
It will take 6 months to only take a decision of
Raiganj, that is 100 kilometers.
Malos, may I just make it short, Malos? I have also filed my report in pursuance of the report which your lordship is having. Malos, they were supposed to supply fly ash. There was delays. There were some issues which they couldn't meet. Today, Malos, the NHA on my own is lifting the fly ash, Malos. The issue is, Malos, only there are two issues involved, which are very brief in nature. I have, Malos, as on 21st of April, that is on Friday, lifted 4.6 LCM of fly ash on my own through my contractor, for which, Malos, they are supposed to issue purchase orders. They are, Malos, delaying issuance of purchase orders, for which my contractor now is no more interested in picking up a fly ash, because certainly he has to be compensated. That is why accordingly he'll proceed further. So they have to, Malos, only do some paperwork that is with regard to issue of purchase orders, so that I can continue to lift the fly ash. That is one issue, Malos. The second issue is that subject to previous commitments by them, Malos, there is a shortfall of 2.48 LCM, which they are yet to supply, Malos. That is arising out of an independent contract between
me and them, which they have shortfalling even today, my lords, they have committed on a number of times. It is not that they have not supplied, but my lords, yes, the quantity and the rate of supply, the time which is being consumed by them is too slow, my lords. So these are only two issues which needs to be addressed. One, the fly ash which is being lifted by NHI on its own contractor, you kindly issue the purchase orders. They are giving me the.
No, any bottlenecks in that? What is, it is procedural only.
It is procedural. They have to, my lords, give me the purchase orders. I'll take reimbursement and I'll continue to lift the fly ash. And it is purely an administrative for which I have I have instructions that I have given
That is
them.
one part of it. We'll issue a direction.
Right, my lords.
So that purchase orders are periodically issued. So that the lifting and supply of fly ash is unhindered, etc. And why don't you explore the option of lifting it from the nearby power plant?
Only, my lords, now, my lords, we have reached a stage where only limited requirement is there, my lords. We have almost reached a conclusive stage, my lords. Almost entire thing has been solved. One is, my lords, purchase orders. The second is, my lords, they have to bare minimum supply 2.48 LCM, which is pending with them. That is what they have to supply to me.
That is the deficit quantity.
That is the deficit quantity arising out of a previous arrangement between them and me. So they may, my lords, supply that 2.48 LCM. They may issue the purchase orders. 2.48 LCM.
My lord, I have recorded that in my minutes.
Yes, we saw that.
That is page 41. This is LCM means lakh cubic meters. You're also layman. Page 41.
Now, how long will it take for you to?
Well, we have already missed the target. It was recorded that February 2023 was the target. Now I was pushing them like anything for February.
My lord, your lordship may have my report, my lords. I have mentioned it that if this commitment of fly ash is met, my lords, I am tentatively giving a schedule of July to August, my lords, which is not very far. But this fly ash.
Which paragraph of yours?
My lords may have my report, my lords, page number 3. Roman number 5 at the top, my lords.
So this 4-laning, that is the entire state.
No, my lords. This is only with regard to district Nadia.
This is only regard to 66 point something.
There are, my lords, 8 districts.
There are
Lordships
more
are
difficult
there,
parts.
it will
I'll
take some
bring
time.
your lordships. This is the part that we have been able to at least initiate
But
construction.
what can the court do? We
My
can
lord,
at most
court is the
issue
person, my lord. If the court, I will bring your lordship to the better parts of the things also. Had this court not been there as of today, but after, my lord, I have been appointed, I have been able to open Malda bypass. I have been able to open, my lord, Islampur bypass. I have been able to open, my lord, Dalkola bypass. I have been able to, my lord, strengthen the road and 4-laning so that from Bagrogra till Jalpaiguri circuit bench, it used to take 4 hours through Dalkola, through that that is through another road, my lord. It was a survey. That was a state highway. Now, my lord, now it takes 45 minutes. There was an order passed by this honorable court.
So today we will take care of Nadia district.
Nodia and Baharampur. I'll be drawing your lordship's kind attention to Baharampur also. There is one issue which also needs to be sorted out. And the other issues, my lord, I am in the process of conducting, my lord. I have, my lord.
In their report, Barakpur is not here.
No,
That is part of Murshidabad.
it's part of Murshidabad. Next part.
is Murshidabad.
I'll draw your lordship's kind attention to
We
that.
have
my
tried to keep it as brief as possible, just limited to the issues which we have
because
raised.
I am
For today, we will issue a direction to NTPC
yes.
to issue purchase orders so that the requisite quantity of fly ash is lifted by NHA.
In
through their
respect of
contractor,
Nodia district.
Nodia. And the deficit quantity of 2.48 LCM also.
But some question is there, my lord, the tender process and other like that. My lord, every day they are given the instruction, my lord.
But it is, no, it is better for you to clear.
Yes, my lord.
Otherwise it is a hazard.
It's a small issue, my lord. Ash, my lord, that is a garbage quantity, my lord.
Because
It
I
can
am-
be served, my lord, anytime, my lord.
I am-
300, nowadays, my lord, 300 kilometers, no more, my lord. Because the highway position is very good, my lord. As far as Farakka and Krishnanagar is concerned, my lord, that highway is very good.
Actually, now what
It used to take 17 hours.
That we are willing to complete this project by July or August. This means we have already come at the bottle end of the project. So only limited quantities left with them. Otherwise, they may, as soon as possible. I am also not saying that to.
No,
because-
you simplify the process of tender, etc.
Tender process and the, my lord, that is the difficulties and.
No, tender, they are a government organization, they want it for that.
Unless we are lifting on our own, we are lifting the fly ash from them.
So he is now, you are not going to incur any cost.
Yes.
All that you need to do is place the purchase order, issue the necessary gate passes so that the
No,
trucks
my lord,
come and.
there is one thing to that. It is not that they will incur in cost. Under the notification, they are supposed to, it is their duty to give it to the place concerned. Now, what happens is that in view of the fact that this is not their main job, their main job is to, my lord, produce electricity. My lord, they reimburse the persons who are picking up the, my lord, fly ash. Under the notification, it says that you have to give it free, so that the fly ash is not accumulated. It causes pollution in the space. So that is why in 2009, I think these notifications came. Yes, 2009, this notification. So it says that it has to be provided free. So therefore, they reimburse them. So that, and that is why they are taking. Now, this tender process has failed.
Oh, no. National Highways is lifting it through their contractors.
Yes, they are doing on the basis of memorandum of understanding that they have entered.
See, the endeavor should be to complete it.
Yes, that is my only thing. No rectification.
As per the terms of the memorandum of
So for
understanding.
today, we will pass a direction for this district alone.
Yes,
The remaining we'll see the progress after.
Certainly, my lords.
as early as possible.
We have heard so also.
Next, my lord, I'll be, my lordship is passing only for Nudia because
Today only
Bahramapur
for,
is also requirement. Kindly gives me 5 minutes because in monsoons will come.
for
my lord.
today, let us see the progress in this.
My lord, Bahramapur, I'll be pressing for Bahramapur also. My lord. Once kindly comes to my lord.
Yeah, and the learned special officer who has been.
Murshidabad,
appointed
that
by
is
this.
No,
Insofar as the district Nadia is concerned, the problem appears to be with regard to supply of fly ash. In this regard, we have heard the submission of the learned advocate for NHAI and NTPC. There will be a direction to NTPC to issue the necessary purchase orders and ensure uninterrupted and seamless supply of fly ash, enabling the contractors of NHAI to lift the required quantity. NTPC shall give top priority for the same, and if any orders are to be passed in this regard, the same shall be passed, and unnecessary delay should be avoided. The deficit quantity of 2.48 LCM shall also be supplied by NTPC to NHA, which shall be lifted by their contractors. Yes.
Plus
Please
the
sit down.
2.488 LCM has to be supplied by them through their contractor. I am not lifting that.
2.48 LCM.
2.24.
Deficit quantity so also shall be supplied to the contractors of NTPC, who in turn will deliver the quantity in the required site. Next, what is the other one?
Kindly comes to, this is bit good news. Kindly comes to page 58. This is, my lord, the page 58.
Yes.
These are the pictures when I was first appointed, my lord. This is, my lord, these pictures were annexed with my third interim report, which was April 2019. This was the pictures then. Now, my lord, kindly turns and comes, my lord, the initiation. This is Bahramapur that just taken by me. Now, my lord, page 60 would show that this is the only part which is small. Yes. Now, my lord, 61, and now kindly comes to the meeting of the chief secretary, which comes from page 63 onwards, 68 onwards. 68, and the relevant part is page 79. Yes. Last part. DM Murshidabad informed that the work of Bahramapur bypass is going on and there is no issues relating to ROA, that is right of way. NHI has made provisions of grade separators at 4 intersections points, but no provision of service road at both side lanes. absence of service road at the said intersectors will defeat the purpose of the vehicles of adjacent areas to use bypass, since the vehicles will have to traverse a long distance through the town to get entry to the highway or reach destination after exit from the highway. Chief Secretary instructed DM Murshidabad to write to the Secretary PWD in this regard for taking up the matter. Now, this letter of the DM is at page 63. Kindly comes to page 63. Previous.
Yes.
The DM has written, it is understood that in spite of having provisions of VUP, NHI has not provisioned for service road at both lanes on these intersection points, and this failure will be essentially defeat the purpose of the bypass, as vehicular traffic will have to traverse huge distance within bypass and through lanes of towns in the absence of this service road. Thus, I would request your kind attention to kindly formally take up this with the NHI to provisions of this service road in the scope. Now kindly comes to the previous page. This was taken up. Page 62. This is the letter of the acting project director to their own team leader. My humble submission is that this proposal, which has been initiated, has to be, my lord, resolved. The project director, team leader, whoever is the person concerned, the regional officer, should sit together and resolve this within 15 days. Because why I say June is the target which I have set for them, my lord. I am trying to push it. They would be opening one side of the Baharampur bypass, so that, my lord, the entire Baharampur city is, my lord, is relieved from the congestion. Now, my lord, by June they will be opening one side. They have said in their report August, but by September both sides will be opening. Now, my lord, if this is now not completed by the concessionaire, that is, my lord, their response, NHI response is at page 3. 3 into 4. Yes, 3. It is submitted.
What they say is, the service road is not included in the scope of work.
That they have to sit together. There are
That is
changes
true,
of
sir.
scope.
How do we say that within 15 days you issue a notification? That is unrealistic.
I am saying that they should finalize. If they give, if they are,
what we can direct is, as per the report at page 5, para 5, page 4, para 5, we can ask them to speed up the process of
Evaluation.
whatever.
Change
of scope of
Yes,
work.
evaluation, whatever.
These are two
If
issues.
they reject, they reject.
These are two issues. One is with regard to the bypass. Bypass, it is an admitted fact that the work is going in full swing. He says June. I have given my report tentatively as August, that we'll be opening one lane in August. Entire bypass will be open to the general public by December. Now, as far as the service road is concerned, we got a proposal from the state administration that kindly take up the service road. Now, with regard to the existing contractor, my lords, it is not a part of the contract. If I ask him to construct that, it will lead to a deviation of what he's doing as of now. Might be. I am not going into that aspect. We are technically, as of today, evaluating this proposal, my lords. There is a submission.
You take a decision. See, what the special officer says is, if it is feasible, you say yes.
Yes,
Not feasible, you say no.
Whatever.
Then they will discuss it at a different level.
Then, my lords,
The
my
learned advocate for
instructions,
the
as I've
district
also
administration
submitted,
is
that
also
it is
there.
being technically evaluated.
You
But
do
let
that.
there not be a rider upon me that evaluate within so many days or so many.
But they should sit together, get it done in one office.
We'll evaluate it
Second
at
issue
the
pointed out.
earliest possible.
Second issue highlighted by the learned administrator is with regard to the service road. In the 4-laning of Berampur, Faraka section.
No, yes.
In this regard,
Baharampur bypass. Lashima kindly specified. This is Baharampur
Berampur bypass.
Baharampur bypass.
Berampur bypass.
In the
In
district,
this regard, the learned administrator has drawn our attention to the meeting convened by the chief secretary, in which it has been stated that absence of service roads at the relevant intersections will defeat the purpose of the vehicles of the adjacent areas to use the bypass, since the vehicles will have to traverse a long distance through the town to get entry to the highway or to reach destination after exit from highway. In this regard, direction was issued to the district magistrate Murshidabad to address the secretary PWD. This direction has been complied with by the district magistrate by memo dated 10th October 2022. It is thereafter the NHAI has taken up the matter, and the acting project director and manager technical NHAI has addressed the team leader URS Scott Wilson India Private Limited with regard to the issue relating to the service road, page 62. URS Scott Wilson. The report filed by NHAI states that the construction of service road in Berhampur bypass is not included in the original scope of the project, and the same is not part of the present contract between the NHAI and the NHAI appointed concessionaire. However, as per the demand of the district administration, Murshidabad, the same may be constructed by way of change of scope or by way of a separate independent contract/tender, that too only if it is approved by the competent authority of NHAI. It is further stated that the construction of service road in Berhampur bypass should not be linked with the ongoing work and completion of the bypass, as both are independent works. The stand taken by NHAI is fully justified, and the service road proposal should not be linked with the ongoing and completion of the Berhampur bypass. As submitted in the report of the NHAI, appropriate steps be taken by NHAI at the earliest with regard to the evaluation of the proposal for service road in Berhampur bypass, and a early decision in this regard would be appreciated. Full stop. The work in the bypass shall proceed as expeditiously as possible, and it will be appreciable if the same is completed well before the target date mentioned by NHAI in its reports.
They will complete by June. I know, I have
May
been
I,
there.
May I seek a short indulgence, Manoj? We have filed a response to the 11th report that may be taken on record, Manoj.
You are opposing its report.
No, Manoj, we are not. We are just throwing light on the fact.
Response given by NHAI to the report submitted by the learned special officer is taken on record.
I am grateful, Manoj. Deeply
And my
obliged.
lord, as recorded, my lord, in the order dated 30th January 2023, my lord, I am in a process of evaluating, again reviewing the positions in the other districts, my lord.
The learned special officer is directed to proceed further with the matter in terms of the directions issued earlier. In terms of the directions issued to the division bench earlier. We will have it sometime in June.
My lord, just after after summer break. I don't have any, my lord. I will do this during the summer.
June.
Manoj, we have after the summer break, Manoj.
6 June, my lord.
No, 3rd week of June.
And my lord, let it come as a specially fixed matter. My lord, this, my lord, there are other issues also which are difficult, my lord. These projects, my lord, one project has been, my lord, terminated. This was being, my lord, directly monitored by me, which has been terminated. 260 crores have been spent in one Mouja itself, but the project could not be, my lord, completed, and the tenders have been terminated. Now, my lord,
They will issue fresh tender.
Yes,
they have the terminated contractors has approached the Honorable Delhi High Court. They have, well, there is an order of stay. Now, what happens is that after
in a section 9 application.
No, not in a writ petition. I have annexed that order.
For vacating that.
I have also said that in my report. It can be, if Lordship kindly gives one line so that petition is
in
there.
this regard, Manoj, not in this matter, because matter is sub judice before the High Court. So, Manoj, I will.
No, you.
Because we are rigorous. My instructions are that we are rigorously contesting that matter and we're taking appropriate steps. But my instructions are also not
getting and all these things.
Not to bring up over here, because then it might affect my interest over there, Manoj.
Yes. Next.
I'm grateful, Manoj.
As a specially fixed, my lord, kindly gives that blessing to this matter. my lord, as a
what-
specially fix on, my lord, a particular date.
That's why we have
Yes,
given a date.
date. Item number 20.
Item 20 is a suo motu PIL. Lord, item 20 is a suo motu PIL instituted under directions of the Honorable Supreme Court of India. The direction is dated 16th of September 2020, which is at page 24 of my petition.
Now, what is the position?
My lord, the position is
All the courts are, no court is vacant, I suppose.
no.
All courts.
All courts have, my lord, what has happened, my lord, this honorable court sought for 2 affidavits. The last of the affidavit was to be filed by the learned Registrar General. That was on the issue of infrastructural deficiencies. My lord, we had filed that affidavit affirmed on the 21st of February 2022. The state has given its response. We want to examine it and come back, my lord, after the vacation.
No, have you got instructions that no MLA MP court is vacant? All have got judicial
My
officers.
lord, the designated court is vacant. There was an issue of, my lord, designating another court for magisterial level trials.
In which place? Here.
Here, my lord, that has also been done and the gazette notification has also been completed.
So all courts have got.
My lord,
I have, my lord, a top sheet, my lord, 2-page top sheet, my lord, giving, my lord, the details, my lord. My lord, the headings, my lord, your lordships will kindly see. My lord, one is pendency. Then, my lord, an appointment of nodal officer, my lord, which was required, my lord, to ensure, my lord, that there is, my lord, all case diaries are made available, facilitate witness production, efficient execution of processes. Then, my lord, establishment of a special court that has happened both for magisterial and sessions. Then, my lord, 13 issues were raised, my lord, in the affidavit of the Registrar General. My lord, we've dealt with those. My lord, the last order says they were to get back with their responses, my lord. That, my lord, has not yet happened. That's the order.
but there,
dated
my lord, I'm
20th
seeking an
March
extension.
2023. My lord, this is the summary, my lord, from, my lord, all the affidavits, etc., my lord, which have been filed.
Issue number 7.
Yes, my lord.
It is not only the judicial officers, the accused who are brought there also.
Correct, has to. No, but the grievance raised was with regard to, my lord, the judicial officer.
But
The
going back to
accused,
recent.
and more so, my lord, more so.
Incident.
More so, your lordship, my lord, right.
And which was the last order where?
My lord, that's the order, my lord, of, my lord,
March.
March 20th, 2023.
All right. We have heard so and so. The learned advocate, learned counsel appearing for the High Court administration seeks further time to file their response.
Yes.
To the report filed by the state. The learned advocate general has handed over a short note with regard to the steps taken, which is also taken on record. List the matter on so and so, whatever date you want to list.
My lord, can it be after the vacation, subject to the convenience of?
Yes, yes. In June, you give a date.
My lord, could it be after the 16th, my lord? After
Yes.
the-
After 16, 19th to 23rd, 26th to 30th, 20th.
Item number 21.
Item 21, I am for the petitioner, my lord, led by Mr. Patterson. Is engaged before Honorable Supreme Court. Kindly make it yours. And the respondent, private respondent also has not filed any affidavit.
What is the issue involved in this writ petition?
My lord, I tell you, lordship. My lord, there are some lands, depressed land, where, my lord, water remains for more than 6 months. The owners are entering into contract with an association of pisciculture. The side owners are the writ petitioners
are saying that it is damaging our crop. This is the issue. Reports were sought for from block development, block land and land reform officer and the district magistrate. Threadbare inquiry was made and report given. And my lord, not only that, in the writ petition itself, the block land and land reforms officer has restrained from leasing out the property, the agricultural land.
For physical.
Yes, at page 21. But this is, to my mind, this is absolutely dispute between the.
But then if their agricultural land is abutting this.
Yes.
Pisciculture, definitely they'll use chemicals. The fish feed which they use contains chemicals. So definitely the groundwater will get spoiled. Because if it is meant for agriculture, merely because they are low-lying lands and the rainwater gets accumulated for 6 months, 8 months, that cannot be used for fishing. I mean, rearing fish.
They are the persons who have taken in lease of.
As per the order, my lord, as was asked for, my lord, we made an application before the concerned authority for, my lord, change the nature and character of this land. From, my lord, this is the, my lord, depressed land. So it can be, my lord, most of the season, most of the year, my lord, these lands are watertight. Now, my lord, in order to, my lord, maintain the livelihoods of the persons, my lord, who are the, my lord, the owner of the land, they wanted to, my lord, to have it, my lord, transferred to physiculture. 2 reports were filed. They are not, the petitioners are not affected by anything. My lord, the reports of DM and the BLRO are, my lord, with the record. My lord, if your lordship kindly have a look to the record.
She wants an adjournment for today.
My lord,
this conversion can't be done.
No, we have applied, let it be rejected by the authority. We have applied that.
Until then, what to do?
Not to make any culture, physiculture.
Now, what is the main relief you want? You don't know what it is.
My lord, kindly see the writ petition.
The problem is it's very easy to take an adjournment. But once again, to list it will be difficult. Then your senior will come, may upgrade it from 700 to item 2.
I appear on behalf of the respondent number, the 8 to 17, private respondent.
All right.
If your lordship will not go through the petition, paragraph number 4 and.
Oh, she is not ready, then what's the use?
No, they raise the grievance that the private respondent are trying to encroach their land. So my lord, my respect to submission before you, my lord, is this. From the prayer also, the writ petition is not maintainable in the form of the public interest litigation.
Let us see on the next hearing date at the request of so and so.
Well, let it be then, my lord, I have posted after vacation, my lord.
Yes, June.
My lord, I am filing my affidavit in opposition as directed by,
Affidavit in
let it be
opposition,
kept on record.
Sir?
Yes, yes, yeah.
But I shall file on the next date, my lord.
Yeah.
June. Next.
Oh. No, এখানে নেই। কত তারিখ?
Item number 22 to 27.
Monthly list of June.
Yes.
Lord, I appear for the petitioner, my lord. The State Election Commission, my lord, has approached the Honorable Supreme Court by way of filing a SLP, my lord. That SLP is still pending, my lord. And I have the last order, my lord, indicating the next.
My lord, there was a stay granted. My lord, that stay has been continued. Matter, my lord, is fixed now on the 11th of July.
11th of July.
Now this is contempt petition.
No. My lord, the election process, my lord, had been challenged, my lord, relating to the municipalities.
Okay.
My lord, directions were given, elections held. There were no election petitions filed, but my lord, there was a direction on, my lord, there was a finding by this court saying it had no jurisdiction to grant relief because it was an election matter, but the CCTV cameras should be made available, my lord, the footage. My lord, that was challenged, my lord, by the Election Commission on the ground that, my lord, nobody had filed an election petition. So, my lord, though they were maintained, my lord, there was really no need, my lord, for that. After having held, the court had no jurisdiction. So, my lord, the Supreme Court, my lord, passed an order, my lord, staying, my lord, the impugned order and further proceedings. My lord, that was passed, my lord, on 9th of May, 2022. That interim order is still continuing.
No, what was impugned in the Supreme Court? Order dated?
My lord, this was, my lord, the
26th
order
April.
dated
26th April.
26th
26th
April
April.
2022.
Now, this is a interim order, is it?
My lord, in the,
SLP.
no, no,
No, no.
my lord, the
This order
final,
dated 26th
my
April.
lord, final, my lord, in effect, my lord, final.
It was even a
in effect.
final
Then
order.
why the matter is still pending here?
Lord, this is pending, my lord. The State Election Commission has approached the Honorable Supreme Court, my lord. That is the
See.
interim order is there, my lord, in that order.
So we will not pass any order. We will say that the proceeding stands closed. In
No,
the,
no, my lord, there was a direction to come back. My lord, it was by and large, my lord, a final order. There was a direction for listing on 13 June. My lord, my
for
lord,
what purpose?
my lord,
May I just
my
indicate?
lord, the reports were to be filed.
There was a direction for conduct of forensic audits and submission of reports before the honorable court, and there was a returnable date fixed, my lord. Now, against that order, my lord, the State Election Commission went up to the honorable Supreme Court.
Very good.
There is a stay which has been granted, my lord. In fact, item 22 to 27, all are, 22 is the main matter. The others are all dependent on this particular matter. Now, this is pending before the honorable Supreme Court. It's made returnable, my lord, in the month of 11th of July, my lord. So the honorable my lord, division bench presided over by His Lordship, the Honorable Justice Prakash Srivastava, as His Lordship then was. That bench was also, my lord, adjourning the matter in view of the pendency. My lord, may kindly take it up sometimes after that date, my lord, after the 11th.
No, what we'll
My
do?
lord, I'll tell your lordship what had happened. CFSL, my lord, Delhi was directed to submit a forensic audit report to the court. And therefore it was, my lord, listed, my lord, on 30th of June.
And there were other reliefs
It is
also.
submitted, we have heard so, it is submitted by the learned advocates on either side that as against the order dated 26th April 2022, the West Bengal State Election Commission has filed an appeal before the Honorable Supreme Court, and an order of stay has been granted, and the matter is now pending before the Honorable Supreme Court. Let these writ petitions go out to the list with the liberty to the learned advocates for the parties to mention for listing these writ petitions after the disposal of the special petition.
I'm grateful. All right, that was initially the submissions made by the petitioner. Now the learned AG was opposing that. Now,
No, actually, we see it's a very comprehensive order.
it's
I don't know why there is a returnable date given.
No, but there were
I'll tell your lordships why, my lord. Directions A to F, your lordships would have seen. My lord, those directions A to F, my lord, required ultimately the forensic report to be placed before the court.
Then further directions.
Yes, that's why. Otherwise, my lord, everything had been dealt with. my lord.
23 to 27 are all dependent on the fate of this particular
After
22.
29 also, up to
Grateful,
20.
your lordships.
29? No, 22 to
That's
27.
Separate, huh?
That's separate, my lord.
That's it.
Up to 27. Go out to the list.
Great.
Item number 28 and 29.
My lord, in 29, item number 29, my lord, I'm for the petitioner, my lord, I'm led by Ms. Sushmita Shah Dutta, my lord, due to some personal difficulties, my lord, she will not be available this week, my lord. However, my lord, there was a direction on the last occasion upon the learned council for the WBSC DCL to file a report, my lord. He has submitted before the erstwhile honorable bench, my lord, to that he will submit the report, my lord, this week, my lord, this day, my lord. And my lord, there was also a direction upon the kindly see the order dated 31st March 2022, my lord. As per the
This is some payment of compensation.
Yes, my
My
lord,
lord.
there are two issues, my lord, three issues actually involved. One was, my lord, the investigation, my lord, relating to the charges of rape, my lord, were required to be, my lord, conducted by a officer, my lord, named by the court, my lord, a team under that particular officer. That has been done. All charge sheets, my lord, have been filed. So, my lord, that has been accepted. The investigation is over. There is no complaint, my lord, with regard to that. Next was, my lord, compensation. My lord, there were 4 incidents, my lord, which were there. My lord, Matia, Banchdroni, English Bazaar, and Deganga. My lord, as far as, my lord, 2 of them are concerned, my lord, English Bazaar and Matia, as on till the last date, my lord, the compensation had also been disbursed, determined, my lord, and disbursed. 2 outstanding were, my lord, Deganga and, my lord, Banchdroni. Now I'm told, my lord, that, my lord, even, my lord, the Legal Services Authority, my lord, was added, my lord, to have, my lord, the information.
My lord, actually,
My lord, I'm told Devganga has also been done, my lord. And compensation has been received.
Actually, as per my instruction, I'm led by Advocate Arindam Shen. For the Devganga and Bansdroni, we have not received any police case number, so it's not possible for us to ascertain. In our brief, we have not yet received the police case number. So, if your lordship can instruct for the
My lord,
that we have no problem.
information I have, my lord, everything was forwarded. My lord, Devganga, my lord, has, my lord, the compensation has been, my lord, received. My lord, I'm told. But my lord, if
What
my
about
Bansdroni, my lord,
Dhoni?
my lord, we don't have information on that. This is the information which has come, my lord.
Verify.
Okay, my lord, if you can give the
Because-
direction to.
Case number can be given.
Yes, my lord, we'll give, my lord, both Bansdroni and Devganga, my lord. Bansdroni to the. No, we'll give it here. Give it. Yes, yes. Of আরে কতবার দেওয়া হয়েছে
সাপ্লিমেন্টারি এফিডেভিট দিয়েছে সেখানে
দেগঙ্গা এটা ইনস্ট্রাকশন আমার
আবার দিয়েছে এদিকে বলছে দুই গঙ্গা
মাসরণীয় তো দিয়েছি এখানে লেখা আছে
পিএস কেসটা দেয়নি বলে বুঝতে পারছি না
P4 টা দেখো annex P4
So we can record this report.
My lord.
But so far as the other Barsha,
Bansdroni, my lord,
Bansdroni,
yes, my lord, I'll give, my lord, the case number, my lord.
you have heard so and so.
My lord, one other issue, my lord, one other issue remains. My lord, one of the reasons, my lord, which was apprehended, my lord, as being, my lord, the reason for, my lord, these crimes, my lord, which were being committed was poor lighting, my lord, in several areas.
Right.
So, my lord, as a pilot project, my lord, the district of Purulia, my lord, was, my lord, taken, my lord, because, my lord, the electricity authorities came and said that this demand has to come from, my lord, the local body, and accordingly, the electricity will be supplied for street lamps, etc. So, my lord, as a pilot project, my lord, I was asked to, my lord, set up, my lord, after a committee was set up, to, my lord, coordinate between them vis-a-vis the district of Purulia. My lord, I did that. Last order, your lordships will find 20th of March 2023. My lord, my lord, this was to be filed. A report was to be filed, my lord. And my lord, that has been, my lord, served to us, my lord, on 6th of April. (2023). My lord, I need to, my lord, respond to this.
So that they have submitted a report to the committee and the committee will have to.
They're supposed to file, my lord, the committee, my lord, was supposed to file. My lord, they have, my lord, a report before the committee will be filed, my lord, by, my lord, my learned friends.
already submitted the report to the
No, but they should be filed here also, my lord, before your lordship.
Reference may be made to the earlier.
My lord, there
orders.
is another peer also, my lord. There is a can, my lord. Can
That
one
we'll
in the
see next.
applications, my lord.
You have
There
heard
is
so and
the
so, no?
enhancement of the compensation. my lord.
The learned Advocate General has placed copy of a report submitted by the Devganga police station stating that the victim girl has been compensated and a sum of rupees 5 lakhs has been received by her. The said submission is placed on record. With regard to the other case, other incident at Bansdroni, PANS, the Droni police station jurisdiction, the learned advocate appearing for the DLSA submits that the
Police station
case number, what is it? Police station case number has not been furnished. The concerned authority is directed to furnish the police station case number to the concerned DLSA. With regard to the direction issued in the order dated 20th March 2023, the committee has taken note of the report of WBSEDCL and has also filed a report. Copy of this same, copy of such report filed before the district magistrate Purulia dated 6/4/2020 is handed over, is placed on record. List the matter on so and so.
My lord, we are appearing for SLSA, my lord.
SLSA.
My lord.
Learned advocate appearing.
49. My lord, I'll give the Bansroni police case number here itself. PS 49,
Dated 19th March 2020.
19 March 2022.
Yes.
Item number 30. 30, I appear for the petition. The matter relates to filling up of water bodies by the land sharks who are in fact the developer of the area. If you permit, I have prepared a supplementary affidavit to bring a translated copy of the documents which are in Pandakula. This is the land records which demonstrates that all these are water body. And
where is the land record?
Land records supplementary. I have annexed the translated copy. The records I have annexed the Bengali at page 12 of the petition. The left hand side column called Sreni. And can you see all these are pond. Can you see the class pond? The translated copy, Khatian number, then class Sreni of the plot is pond.
Now, who are these private respondents who are doing this?
Yes, and the last page of the supplementary affidavit, the notice issued by the PL and LRO to stop to stop any further conversion.
They have not taken any action.
No steps were taken.
What is your instruction, sir?
I tell you, Lord. This is admittedly recorded as a tank. There is no dispute on that. His allegation is that some promoters are making construction. Who is making? He has not spelled out. Paragraph.
No, he has implemented them as respondents.
And I have made a specific name in the paragraph.
Beauty Malik and Nirmalya Ghosh.
Kindly see.
Beauty Malik is the officer at whose instance this is being done.
Paragraph 4 of the
officer of the
these private respondents are the officers of the concerned area. Working in the PL and LRO office.
You say that.
And I have made specific allegations against them that they are taking money from the people who are carrying construction. I have made specific allegations.
What have you done pursuant to this notice at page 7? BL and LRO.
This is today just now supplied to me. Page.
I have served.
Just now I have got it.
After advocate and record.
No, you implement this notice immediately.
Yes. There is no difficulty.
This is a stop work notice. They have to restore the water record.
By this writ petition filed as a public interest litigation, the petitioner seeks for a direction upon the official respondents, more particularly the third respondent, the second and third respondent, to restore a water body. The petitioner, by way of a supplementary affidavit, has filed the land records which show the land in question are registered as pond. The learned government advocate appearing for the official respondent does not dispute the fact, and it is stated that the property, the lands in question are registered as a pond. The specific allegation is that the fourth and fifth respondent, namely Beauty Malik and Nirmalya Ghosh, both are who are officers working in the office of the Block Land and Land Reforms Officer, North 24 Parganas, are helping the encroachers to fill up the pond and put up and attempting to put up construction for certain illegal gains. It is also brought on record by the petitioner that already the block land and land reforms officer has issued notice to those persons who are engaged in the filling up of the pond, and they were directed to stop conversion of the area illegally. And a hearing was also scheduled to be held. However, till date, nothing appreciable has happened, which has necessitated the petitioner to approach this court by way of this public interest litigation. As long as the classification of the land as pond is not disputed, the second and third respondent are to ensure that the property is preserved as such. Therefore, there will be a direction to the second and third respondent to immediately take action on a war footing basis, remove all the encroachments. If any part of the pond has been filled up, they should be the same should be removed, and the pond should be restored to its original position.
My lord, I was suggesting, as law contemplates, direct the owners to restore. In their failure, the district magistrate will restore and
they will
what
not.
is?
The cost of such restoration shall be recovered from such of those persons who have illegally encroached the pond and filled up the pond.
No, owners. Owners, recorded owners.
Recorded owners.
Yes.
The owners illegally filled up the ponds who are stated to be the recorded owners. Apart from that, appropriate action be taken under the relevant law against such of those persons who have done the illegal conversion after issuing notice and affording an opportunity of hearing.
Blood hearing, blood, I have a specific state in my jurisdiction, there is continuous threat. Therefore, blood, the villagers are not in a position to blood participate. Blood.
This direction be complied with within a period of 4 weeks from the date of receipt of the server copy of this order. If there is any threat perception to the petitioner or any other villages, and a complaint is lodged with the local police, necessary protection be given so that the hearing, during the course of hearing, which the BL and LRO may conduct, no untoward incident should occur.
My lord, kindly make it 8 weeks because it's a huge fund.
Next.
Item number 31.
Diploma.
I'm for the state respondent.
Lordship, on behalf of the petitioner, Your Lordship, praying for not today, Your Lordship.
I prefer respond number 14 here.
Yes. What action have you taken illegally filling up the pond?
Well, we have already conducted an inquiry
By then he would have filled it up.
by the revenue.
Then what happened after the inquiry?
Well, the inquiry has already been made, and field inquiry, it is found that none, any of the portion has been, it is only the fencing of the bamboo plot.
Here for the respond number 14. The allegation is against me that we have been filling up the pond illegally. No such activity is being carried out by us. We purchased the land sometime in 2020. This was a pond, Lordship, although the nature and character of the land was ours, that's agricultural land. But by efflux of time, water has filled up in that area. And even as on date, Your Lordship, there is no construction activity that we
But as long as it is classified in the land record as pond, you can't.
No. Classification is the agricultural land.
Agriculture.
Agricultural land.
Then you file your
House, the record of rights, it is Amon, my lord. Kindly come, my lord, in the report. Or
report we don't have.
report down. See, report down.
Then you give copy of the report to the petitioner also.
তুমি রিপোর্ট দাওনি কেন?
Disputed plot is Aman.
Yes.
Is low land and remains waterlogged. So it's not a water body.
It is not a pond.
See, the problem arises, you don't give a reply to their representation. If suppose you give a reply, see the land record and say, sorry, your representation is incorrect. Classification of land is so and so agriculture. There may be water logging, but it is not classified. Then automatically they will challenge that order or produce some other earlier land records to show that the original classification was a water body. The problem is because you are sitting tight on the representation, they are coming to this court and filing these. Where is the representation? They don't get an opportunity to challenge. That's the problem.
My lord, the record of rights is, my lord, it is a public document and annexure R1.
You should have.
My lord, kindly come, my lord, the annexure R1 in my report that all these plots are the Amon. It is in Bengali. Amon, that means the, my lord, the one type of paddy.
Mr. Mahato, it has also been converted to homestead. Kindly come to page 4 of your report.
My lord.
Conversion has also been cancelled.
Now the conversion has been
Conversion order has
cancelled.
been cancelled.
Yes, conversion has been cancelled.
Please come. By this public interest lit petition, the petitioner seeks for direction upon the authorities to take action against the alleged illegal conversion of a pond for the purpose of putting up construction. In this regard, a representation was given to the authorities and sent by speed post on 25th June 2022. Since no action was taken, the writ petition was filed. The additional district magistrate and district land and land reforms officer, Murshidabad, the 9th respondent, has given written instruction to the learned state advocate, in which it has been stated that
After revocation of the conversion certificate, what is your order?
My
How
lord.
it is to be maintained?
Yes,
Page 9 of the report.
my lord.
How it is to be maintained?
Page 9, 10, 11, my lord, all these are, my lord.
Says it is to be maintained as a water body.
Yes,
So it's not an aman.
not a,
That is the order passed by this SDLRO.
SDL, yes,
It is to be maintained as a water body, not as an aman.
not as an aman.
So you are saying aman.
My lord, the record of rights says,
This
aman.
is your latest order of July 2022.
My lord.
has given written instruction to the learned state advocate by letter dated 29th August 2022. Along with the said letter, there are annexures, and it is pertinent to note the annexures dated 4/7/2022, which stated that the conversion certificate issued earlier has been revoked by the subdivisional land and land reforms officer, Jangipur, and on the ground of misrepresentation of the actual status of the suit plot of land, and the private parties were directed to maintain the status quo of the land as before as an water body. As long as this order has remained unchallenged by the private respondents, the land has to be maintained as a water body. Accordingly, the writ petition is allowed, and there will be a direction to the private respondents to maintain the land in question as a water body, and the official respondent, namely respondents 2 and 3, are directed to ensure that no conversion takes place. And if any person indulges in any illegal conversion, strict action should be taken in accordance with it. Hello. Next.
Item number 32.
For the petition, my lord.
Read the papers. Luckily,
My lord, there is a encroachment while constructing a building. A part of the public road has been encroached. So the public has been suffering because the road has been narrowed.
and what happened to your representation?
Representation was
Where is the representation?
yeah, representation is at
Page number?
Yes, page number 18. No action has been taken by the municipality.
That is North Damdam municipality has to take action.
Not Damdam municipality.
We will direct them to take action, conduct an inspection.
Yes.
By this writ petition, the petitioner seeks for a very larger relief. But however, the grievance appears to be about an illegal and unauthorized construction alleged construction alleged to have been put up by blocking a common passage. In this regard, a representation has been given to the
Respondent number 2 and respondent number 4.
Who is the writ petitioner?
Writ petitioner is Orindam Mitra. Yeah, he is a common citizen there.
No, is it a private dispute?
No. He is neither the landowner nor the.
Representation has been given to the fourth respondent on 10th of August 2022, and alleging that no action had been initiated on the representation, the petitioner has approached this court. It is not clear as to whether the representation was received with the fourth respondent. In any event, if there is any complaint of directing the petitioner to submit a copy of the representation along with a copy of this order and submit the same before the fourth respondent, who shall inquire into the matter after notice to all concerned and take action in accordance with law as expeditiously as possible. Next.
Grateful, my lord.
Item number 33.
But I appear on behalf of the respondent number 17.
17.
The several occasions adjournment has been sought for and the matter was adjourned.
Respondent 6, 7. Well, I'm appearing for 6 and 7, my lord, and the railway administration, my lord. This is principally against the railway administration, my lord. The doctors under the administration.
We are the suppliers of some ventilators. During COVID period, we supplied. The allegation is that the doctors are not being transferred with some motive, and there is some connivance with the doctors with the suppliers. That's the allegation. And page 37.
The doctors are not made a party.
My lord, they have been made as parties. The principal grievance is, my lord, who will supply to the hospital. Now, a person claiming to be a trustee of an NGO, which was born in 2022, my lord, files a writ petition, my lord. Your lordship will kindly come to page 5, my lord.
Of the writ petition.
Of the writ petition, my lord. My lord, his allegation is, my lord, may I place paragraph 3. Your petitioner states that they have gathered some information from public domain and from other reliable sources that there has been huge misappropriation of public money in Eastern Railways pertaining to purchase procurement of medical equipment. My lord, then he goes on, my lord, without a single, my lord, evidence, nothing, my lord, all allegations are vague. My lord, then thereafter, my lord, if your lordship kindly takes paragraph 11, then comes the real story. He's after the doctors. Paragraph 11, your petitioner states that the maximum procurement for the COVID fund at Eastern Railway has been done from a company named Science and Surgical, being the respondent number 17 herein, whom the said Dr. Such and Such has been favoring since long. My lord, this is a completely false allegation. We have procured from 14 different establishments, and the cost has been lower than what the military has purchased.
All right,
Right.
come.
As we have given the
None-
lowest
none appears
quotation,
for
we
the
have given.
petitioner. From the order sheet, we find even on earlier occasions, none appeared for the petitioner. On going through the affidavit filed in support of the writ petition, we find the allegations made are absolutely vague. And the petitioner would state that he has gathered some information from public domain and other credible sources. The source of such information has not been disclosed. Further allegations in the affidavit shows that there is certain personal bias as against a few doctors. With such vague allegations, we cannot entertain a public interest litigation. Therefore, writ petition is dismissed.
Obliged,
Next.
madam.
Item number 34.
Hmm? 24. Pass over.
Item number 35.
Pass over.
Item number 35.
But I appear for the state respondent.
What is the prayer, sir?
Blood,
Somebody is filling up the pond.
No, nothing.
From
He's saying
morning,
so.
we are digging all the ponds.
But kindly sees paragraph 7 at page 6. He believes that it is a pukut. No record of right, nothing is annexed. No homework has been done. No survey has been made. And this falls within Kolkata Municipal Corporation area.
Withdraw the decision or permission, if any, given by them to the prayer to cut trees adjunct to water body, amalgamate, capture.
These are the function of Kolkata Municipal Corporation. And commissioner is the authority.
They gave representation on 7/9. I think on 10/9 they filed the writ petition.
Kindly sees.
At least they could have seen the representation or something.
Kindly direct the Kolkata Municipal Corporation to Malad.
None appears for the petitioner. Petitioner by this writ petition seeks for a direction to withdraw or cancel any permission, if any granted, to the private respondents for cutting down trees which are alleged to be adjoining a water body. The
Record of right not annexed.
the averments in the writ petition are very vague, and the annexures to the writ petition are a couple of photographs and copies of representation. Therefore, with this vague averments, we cannot issue any positive direction as sought for by the writ petitioner, and suffice to direct the which respondent. The second respondent to look into the representation dated 7/9/2022 and examine as to whether any illegality has been committed. To facilitate this process, the petitioner is directed to enclose a copy of the said representation along with a copy of this order and place the same before the second respondent for initiating action. The above direction be complied with within a period of 3 weeks from the day. You please inform. Next.
Item number 36.
I am for the petitioner in this matter, but I am for the response. Well, a railway track was intervening the passage of the villagers to go to the government office, school, college and everywhere.
You want underpass?
I wanted underpass, and the DM's report also speak of page 64. At page 65, it starts from.
Railways are not agreeing to construct.
But may I submit my report on behalf of railway authority?
Everyone is saying it is
Railway authority
required,
is
but
admitting, my lord, that it is required. And sufficient space are there, subject to, my lord, the
acquisition.
Yes, sir. The fund is required from the state. As per the railways, my lord,
That's the problem.
Yes, my lord.
My lord,
They have to.
You give the money, they will
my lord,
construct.
my lord, I have submitted the detailed report in the form of affidavit. It is the existing, my lord, gate. So, my lord, the railway is to here. And I have given the hearing, I have passed the, it is the existing, the railway forcibly, my lord, closed the gate. And from inquiry, it is revealed.
only 5 crore is involved, my lord. The estimate has been given at page 68.
No. How to sort out this problem?
That is the only problem, my lord. If they.
50 be given, my lord, by percent to lordship direction.
No, my lord,
The railway 50%.
as per my lord, railway board's guideline, my lord. But the.
If it
all
is
sorts should be
existing, yes,
Where is your affidavit in the?
my lord, I have submitted the report in the form of affidavit. My lord, I have submitted it on. Yes.
Yes. Which paragraph?
My lord, paragraph 5, my lord.
Yes.
Details of the report has been, my lord.
Paragraph 6 are relevant. 6 are relevant.
Yes, 6 is also relevant.
Now, the allegation in this report is
My
there
lord,
is an existing railway gate which has
Yes.
been closed.
Yeah,
There are 2 ways of it. If suppose you don't have funds, you have a manned level crossing. You remove the whatever iron pillars you've erected, have a drop down gate, manned level crossing you have, you maintain it till the underpass is constructed.
yes.
But my report says, my lord, after taking inspections, that was unauthorized level crossing. Local peoples are crossing every day through that.
My lord,
That is
it is from
unmanned.
inquiry.
Unmanned
Inquiry
level
record of rights.
Unmanned.
Which is your report?
But my report,
Exception to the report.
no, that is no. Just now I have submitted my report.
Railway has blocked it.
Yes, railway has blocked it through erecting iron
Iron
concrete
pillars.
pillars. Iron pillars. It is from enquiry.
And page 10, the subdivisional engineer Eastern Railway's report, can you look for once of their affidavit?
আমাকে তুমি দাওনি কিন্তু এফিডেভিটটা কি তোমাদের এফিডেভিটটা দিয়েছো আমাকে?
হ্যাঁ হ্যাঁ, research.
তোমাদের এফিডেভিটটা আজকে তুমি যেটা দিলে না এটা তুমি এক্সেপশনটা দিয়েছো রিপোর্টটা দাওনি
17/9/2015.
Where is the order passed with the DM Malta dated
my lord
26th March?
my lord that is the order is my lord at page
26 March, page 66.
page 65 starts.
Page 65 starts, it's relevant part 66, order number 4.
এই রিপোর্টটা তুমি তোমার রিপোর্টটা দাওনি আমাকে
আমাদের রিপোর্টটা স্টেট করে দেননি সব করুন
But but there is a specific finding
my lord
stating that there used to be a railway crossing with
Yes.
a controlling guard in the past.
yes
On the spot, it is found railway authorities has blocked the crossing by erecting iron and concrete pillars. Platinum only road connecting so and so to the west of the railway cut so and so. Thus, the divisional railway manager, Malta Eastern Railway, directed to conduct a survey within 3 months, technical initiate action for constructing a underpass. But the finding has been rendered after hearing the railway
Yes.
authorities that there was a controlling, there was a manned level crossing. And where is your exception to the report?
Only thing, my lord, my responsible submission, my lordship, my lord, so far the present situation is concerned, what is the grievance in the writ petition? They are seeking one, the subway to avoid accidents, etc. Because surrounding there are many schools, children are going every day. My lord, my responsible submissions, my lord, there is a clear, my lord, there is provisions under the railway, my lord, boards, rules and etc. To that extent, my lord, if any proposal comes from the state and they are to sponsor, we are
So
ready.
there are two things. You have taken a stand that it is an unmanned, unauthorized level crossing. On inquiry conducted with the DM in your presence, it has been held that there used to be a controlled level crossing. Controlled, there was a railway crossing with controlled guard in the
Controlled.
past. This finding has attained finality, or in the sense you have not challenged it. There is an order, speaking order. So there are two things you can do. One is, till the underpass is constructed, you make the railway crossing with controlled guard.
Very.
You make that
Yes.
for the present. Then you make a proposal, because there is a direction to conduct survey, and you make a proposal for underpass. Suppose you want a partnership basis, you write to the state government, you give us 50%, we put 50%.
Yes, if this proposal comes from the state, my lord,
No, you have to initiate the
you have
proposal, because it's an existing crossing. So you, until the underpass is constructed, whatever may be, your funds, his funds, 50-50, you restore the original railway crossing.
yes
My lord, kindly fix a time limit within which the entire thing is
By
to be
this writ
completed
petition.
and matter be returnable to a lordship's court, my lord.
By this writ
returnable
petition,
Can
filed as a
probably
public
তারা
interest
কোনো
litigation,
proposal দেবে,
না, না,
টাকা
the
দিতে
petitioner
চান,
seeks
তখন
for a
খুলে
direction
দেবে।
upon the respondents to construct an
ওই
underpass
আন্ডারপাসটা করবে না?
in the underpass or underground subway in level crossing of Chamgram railway track, Malda, on RS plot number 173, LR plot number 89, RS Kaitan number 2,
কোনটা এটা?
LR Kaitan number 1929, Mausa Lakshmipur, JL number 36, block Kalaichak, Roman 3, district Malda. The stand taken by the railway administration is that there was no existing railway crossing in the said area, and if at all the same has to be constructed, funds have to be sanctioned by the state government. This issue was adjudicated, no, this issue came up before this court on an earlier occasion, where a writ petition was filed in WPAP number 40 of 2022, wherein a direction was issued pursuant to which the district magistrate Malda held a joint meeting with the concerned railway authorities and representatives of the you are an association of the petitioner association, and after elaborate discussion, a recent order has been passed on 26/3/2022, which reads as follows. Page number 66. I will mark it up to this one, 66. On perusal of the above order, it is seen that the issue as to whether there was a railway crossing in existence or was it an unauthorized railway crossing was adjudicated in the presence of the senior officers of the Eastern Railway, and a finding has been rendered by the district magistrate stating that there used to be a railway crossing with a controlling guard in the past. And on spot, it is found that the railway authority has blocked the level crossing by erecting iron and concrete pillars. Thus, as long as the order passed by the district magistrate dated 26/3/2022 remains valid, it has to be concluded that there used to be a railway crossing with a controlling guard in the said location. Therefore, two issues have to be complied with by the railway administration. Firstly, the railway administration is directed to restore the railway crossing with controlling guard in the said location within a period of 3 months from the date of receipt of the server copy of this order. Thereafter, as directed by the district magistrate, the district railway manager, Malda, Eastern Railway, shall conduct a survey of the area within a period of 3 months with his technical team and initiate appropriate action for construction of underpass at Chamgram, CHAMAGRA. With the above direction, the petition shall stand.
My lord, it is to be mentioned that the land is concerned to the railway, my lord. The finding of the DM is that land belong to the railway. The land is also belong to the, my lord, kindly come, my lord, considering the section 17, the land belong to the North Frontier Railway. So the land is also to the railway.
By erecting a railway crossing after removing the iron pillars.
Well, so far the finance part is concerned, that has to be when a railway authority shall go by its own regulations. Right?
Kindly look at page 68. They say that I will not fund it.
State has to make
the railway authority has said.
As of now, you will get a railway crossing. Next.
Item number 37.
So far as the fund part is concerned, Lordship may kindly give some direction.
That as long as the order of the district magistrate is there, they have to construct. Next.
Item number 37.
Lordship disposed it of.
Yes.
But I appear for the states.
None appears for the petitioner. Even on 2 earlier occasions, none appeared for the petitioner. You have heard so and so for the respondents. Dismissed.
Item number 38.
I am for the state. Item number 38, Mr. Narayan Chandra Mandal is appearing for the petitioner. Due to his illness, he has not come today. Kindly takes it up on the next week. I am praying for not this week.
Now, today or never. We can't adjourn it, sir. Sorry. Mandamus.
I appear on behalf of the private.
Illegal unauthorized construction of on the playground of primary school. What is the construction?
The allegation is totally false, my lord. Against the private respondent.
But some photographs have been included. What is the construction?
I don't know, my lord.
The allegation is that a temple is being constructed by the persons, the private respondents. And my lord, already, my lord, the matter has been referred to the district inspector of school for inspection, and the district inspector will take action if there is found any illegal
You
construction.
remove it, remove it. No temple inside.
No temple in the school, my lord.
The
I am
petitioner
also,
by
my
way
lord,
of this public interest,
Yes.
please, petitioner by way of this public interest litigation seeks for a direction upon the respondents to immediately stop illegal and unauthorized construction in the playground of the primary school. It is alleged that construction is being alleged that steps are being taken to construct a temple in the school playground premises. The learned state advocate submitted that already action has been taken, and the district inspector of schools primary education, North 24 Parganas, will look into the matter. Therefore, there will be a direction to the second respondent to immediately conduct, second respondent along with the fourth respondent to conduct an inspection of the school premises within 1 week from date. And if any unauthorized illegal construction is being made, the persons who have put up the same should be directed to demolish the same and restore this land as a playground. If they fail to do so, then action be initiated by government machinery and the cost of such demolition be recovered from the persons who have put up the unauthorized construction. The above direction is issued on the basis that the land in question has been allotted as a playground. If it is otherwise, then it is open to the authorities to pass a speaking order on merits and in accordance with the law. Disposed of. Next.
Deeply relevant.
Item
My lord,
number-
instead of, my lord, 1 week, 2 week, inquiry by 1 week, it is 2 week, my lord.
1 week.
I am praying, my lord, 2 week.
2 weeks. Within 7 days, I said. Within 2 weeks. Next.
Item number 39.
Deeply relevant.
I am appearing for the petition. In our state, my lord, the distribution of scheduled type land my lord, is in majority in the northern part of our state, my lord, the hilly areas, the tracts. My lord, there is also one peculiar feature. My lord, I shall invite your lordship to the main point, but just 2 things I want to place before that. My lord, the peculiar feature is, my lord, this state and Tamil Nadu, my lord, doesn't have scheduled land, but it has a tribes advisory council. My lord, 244 of the constitution article, my lord, says that schedule 5 will be the governing logic and philosophy for any scheduled tribe throughout the country. Now, my lord, with these 2 poles of constitutional reckoning, my lord, in between, this is a case where, my lord, tea garden owners who are blowing their golden pipes in Calcutta, smoking their pipes in Calcutta, my lord, have grabbed tribal land. Now, my lord, with the report of the respondent number 7 coming in, to which I have made an exception, my lord, the matter is now put to rest and I am vindicated. The thing has narrowed down. My lord, the government, my lord, the report is there. My lord, I am just placing the facts. My lord, I have made an exception to that report.
And what does that report say?
My lord, the report says that, I'll tell you, lordship, what has happened. Report says that the private respondent, whom I am alleging has grabbed land, is not a land grabber. He has got land in 2 ways. Lord, my case and the report is pretty same. Lord, the report says in Khatian number 852, he has got about 62 acres of land, which he has purchased from individual landowners who are tribals, according to the report. I am making a main allegation in the petition, my lord, that there is no 14C, the clearance, statutory clearance, which is required. Lord, the government.
But can they purchase it?
No. Lord, my main contention is narrowed down. My main contention is there is no 14C, there is no purchase, manufactured deeds, grabbing of land. Lord, the government comes and gives a report, Lord, 7, respondent number 7, the same thing, but remains very, very quiet about 14C. Lord, admits that the land belonging to Khatian number 852 is tribal land, gives the list, that list matches with my list, everything. But the government is required, my lord, to spell out the beans before this court and come clean that yes, there is 14C or no 14C. With 14C, I'm out of court. Lord, they remain silent. Now, the next part, why the government remains silent? Lord, next 21 acres, Government says, he also says, private respondent also says, government also claps along with him. Yes, sir, 3 bags full, sir. Government has leased him. Government has from Khatian 1, which is the state land in West Bengal, Khatian 1 is all government land. From government land, state has given him lease for making tea garden.
21 acres.
21 acres. And those 21 acres, my lord, the porcha is in my name. My lord, scheduled tribe land cannot be resumed by the government to give it to a private entrepreneur. My lord, that law, if that law is there, my lord, your lordship should send 2 lines.
But Kaitan number 1255 has been assigned. So how do you say it's a tribal land?
My lord, 1255, they are saying that it is government land, Khatian 1. My lord, I am showing porcha. My lord, that is the land record, old revenue CS, RS record, my lord, traditional. There are 5 generations, 7 generations sitting there. My lord, I do not know when it has become government land. My lord, all that should be brought before the court. Then I can examine from how it has been resumed. My lord, porcha is in my name. All right, with the lease part, they may give fresh report to your lordship. But with regard to 60 acres, my lord, this poor tribal, my lord, we complained to the governor, invoking 244. The governor, my lord, honorable governor of the state, my lord, before he went to take higher office of vice president, my lord, his office, my lord, has given a letter to the concerned secretary that I hear that there is grabbing of land. Kindly give me a report. I do not know what report has gone to the governor. Because ultimately, my lord, schedule 5, which is of constitutional importance. My lord, the ordinary law of the land, my lord, inside the Constitution of India, my lord, today I am submitting, my lord, there exists another constitution, which is the constitution for the scheduled tribes. My lord, when the Britishers left our country, my lord, they left 3 Indias: the British India, the princely India, and the tribal India. My lord, there is reflection in the government of 1935 Act. It is that act which brought into the existence of this phrase schedule. My lord, it's a constitutional continuity. My lord, it cannot be breached by mere report submitted by a government official. And that also not correct, not perspicuous, not transparent enough. My lord, I have said that in my objection. My lord, kindly take the report filed by respondent number 7. My lord, I shall demonstrate from there. My lord, kindly take the report.
No, the one second, before. In your report, in page 8, paragraph F, you have stated that so-and-so private limited is in possession of land under Kaitan number 852, which is comprised of 63.90 acres, wherein total 38 plots are recorded. His allegation is this is tribal land. How did he purchase this land? Is his allegation. Your report is lacking in that information.
That is precisely my point.
See, even if assuming some transaction took place, if it is impermissible under law.
Absolutely. No
it
questions
really-
on that. No questions on
And
that.
who will appear for the 7th respondent?
Well, I appear for the 7th responder.
No, sorry, for the
Private
Private respondent, none is appearing, my lord.
they have been served.
Endless suits, they file police complaints. I take RTI and RTI says nothing, all false. Hospital records, all false. But I write to the concerned authority. Authority says, I don't know. That also I have annexed in my objection.
We have heard so and so. A report has been filed in the form of an affidavit by the 7th respondent, wherein it is stated that Messrs. Rebati Agro Private Limited is in possession of land under Kaitan number 852, which is comprised of 63.90 acres of land, wherein total 38 plots are recorded. The petitioner has filed an exception to the report, pointing out that the various DAG numbers mentioned by the 7th respondent in the report pertain to Kaitan 852 are mainly belonging or recorded in the name of scheduled tribe riots / owners. And shockingly, the 7th respondent has deliberately evaded the issue regarding non-existence of statutory permission mandatorily required to be obtained under section 14 capital C of the West Bengal Land Reforms Act 1955 for transfer of ST land to non-ST persons. Further, further in the report of the seventh respondent, it has been mentioned that that in the other Ketan number 1255, a lease deed has been executed by the government in favor of the private, in favor of Messrs. Rabati Agro Private Limited by lease deed dated 4th August 2009, bearing number 2384. In respect of an extent of 21.03 acres of land which was recorded in favor of the collector on behalf of the government of West Bengal in Ketan number 1 with LR plot numbers 1030, 446, 448, 459, 476 and 477. It is submitted that it is not clear as to how the said lands in question were recorded as government lands. And the report of the seventh respondent also does not disclose as to when and by which order the lands were shown as government lands. Please. In your exception regarding 1255, you have not said anything.
My lord, I have exception. My lord, in exception, my lord, if your lordship kindly takes, my lord, page 15, page 14, my lord, page, sorry, my lord, page 12. Page 12. This is the RTI which I wrote to the concerned authority, my lord, district magistrate of Alipurduar. This is the RTI. My lord, the reply, my lord, is astoundingly startling. My lord, page 17. Kindly take page 17, my lord. To all the questions which I asked, to all, my lord, there is only one reply. Information sought for is not available.
No. Their allegation is these 5 or 6 plot numbers are recorded as government lands.
Exactly. Yes.
Your contention is how it became a government land, nobody knows. But in your exception, you have not pointed out anything on that. So far as Ketan 1255.
Well, 1255. With that, my lord, sorry for repetition, my lordship, forgive me. My lord, in page 12, I have given an RTI query asking as to how it has happened. I've asked all the questions, my lord. All the questions that when it was resumed, how it was put in with respect to those plots which I am concerned. Lord, kindly take page 14. And will you kindly take the reply at page 17? Reply at page 17.
Thus, furthermore, from annexure 15 to the report of the seventh respondent, it appears that there was a meeting held with the company and the complainants and the police, and the matter was discussed. And a resolution was also recorded. However, the copy of the resolution has not been appended. Therefore, we direct the seventh respondent to file a further report setting out all details in a clear manner and enclose the necessary resolutions, enclose the copies of the resolutions which were passed during the said meeting.
May I,
2 weeks.
may I benefit from an urgent server copy of this order?
Yes, urgent server copy.
I will
give a
make
date
one-
after 2 weeks.
I will make one small submission before your lordship rises. Lord, that discussion which the police held with the company and the tribals, Lord, is prohibited under the clause guidelines. You cannot mediate. He has done exactly that.
No, if it is registered under that particular, for the particular purpose, it can't be converted. That much is clear. Yes, it is.
May I have 3 weeks of time? This
3
is from
weeks.
Alipurduar. my
3
lord.
weeks.
But for my lord's rise, my lord, I was troubling your lordships, my lord. An order has been passed at 11:30 today by the honorable single judge. This pertains to, my lord, the West Bengal Judicial Service examination. Now, in the preliminary examination which was conducted, now the results are supposed to be published. They have informed that tomorrow the results will be published. Now, on 2 grounds, the challenge was made, my lord. One is, my lord, the key answers. These are the competitive exams, the preliminary examination, the purpose of which is for screening. Now, 7 key answers are wrong. And it is, my lord, the marking is done by way of, my lord, optical marking. So 7 answers are wrong. This is one aspect. So I will be prejudiced, the candidate. And second is, my lord, a decision has been taken that in respect of 6 questions, grace marks will be, my lord, awarded to everyone, irrespective of attempting or not. My lord, there is a negative marking concept, my lord. This is done pursuant to the guidelines laid down by the Honorable Supreme Court in Malik Mazhar's case, my lord. My lord, now the interim order, my lord, which was there, which was granted on Friday, my lord, now that has been vacated, my lord, and a report has been called for. So, my lord, there will be extreme and severe prejudice and also accrual of third-party rights if the result is published tomorrow, my lord, without the matter being heard. I was humbly beseeching your lordships, my lord, if my lord, leave is granted to prefer the appeal, my lord, without the certified copy and move the application tomorrow morning, my lord.
Lord, I will, my lord, I appeared on behalf of the state respondent in this matter, my lord. I must indicate this to your lordship, my lord. The interim order was passed. On this court, the answering respondent, being the Public Service Commission, was not present before the court. Today, the Public Service Commission has tendered their appearance, my lord, and Honorable Judge is fit to vacate the interim order.
That order copy is enclosed.
Well, it has been passed at 11:30. We understand, my lord,
But how without even a server?
my lord can always, my lord, call for the fine, my lord. This is a
No, no.
continuation of the, no, and my lord, we presume, my lord, by tonight, my lord, it will be there in the server, my lord.
Leave
Otherwise, my
granted,
lord, by
leave granted to file with server copy. You return the book.
Original side matter, item number 1.
But I'm appealing for the appeal. May I
I
find the
am
service,
for
my lord?
the
So there's a
respondent.
delay of 974 days in filing the appeal, my lord.
My lord,
But the questions are very interesting, Your Lordship, my
my
lord.
lord,
Against the 263 order, my lord, but the questions are very interesting. Your Lordship will kindly see, my lord, page 11, paragraph 7, the
lord,
questions, my lord, here.
no satisfactory
My lord,
explanation.
because of the COVID, my lord, the
Two matters already heard by your lordship.
Lord, item number 3,
1, 2, 3, my lord, I'm appearing, Mr.
4, 5, 6, 7, my lord, I am appearing.
It's a common order, my lord, of 9 matters, my
Plus
lord.
9,
5, 6, 7, my client has not received.
my lord, we have
Yeah,
served,
received
my lord, we have served, my lord,
3.
my lord, we have served, my lord, may I also, my lord, giving one copy.
You received for.
My lord, interpretation of section 54 EC, my lord, is there, my lord. My lord, what actually happened when the client has, my lord, sold the paintings and, my lord, invested in a bond, my lord. That was investment was made beyond the period of 6 months, my lord. So whether, my lord, he is entitled to get the reduction on section 54 EC, my lord. That's an interesting point. If your
My
lordship
lord, two
kindly
matters
sees, my lord,
already ordered passed, my lord.
on the
And there is no satisfactory explanation. Lordship has given
my lord,
elaborate order on that.
the order
matter.
was passed in 2020, my lord. My lord, then
No,
my lord,
it is the same as the
Yes, my
same, my lord.
Same batch,
It's the
my lord.
same batch of, my lord.
Family,
Nine
family
matters.
members, my lord, 9 family members, my lord. Now, my lord, problem is that, my lord, in my, my lord, conventional delay application, my lord, the department has says, my lord, for filing or appeal, my lord, the 9 copy of the, my lord, order, ITT order and certificate copy required. My lord, for that, my lord, purpose of,
No, you can always seek for
my lord,
dispensing
that
with.
is, my lord, that is there, my lord, they have not, my lord, they have,
They should be aware.
Order was passed on 20
not only that,
February 2020.
and not only that, my lord, the order passed in the, my lord, just threshold of the, my lord, COVID
COVID,
period.
yeah, that's why I'm not what I'm humbly
No, my
submitting
lord,
that
lordship.
kindly condone the delay subject to
Lordship.
lordship will kindly hear out because it's a question of interesting question, lord. Whether, my lord, interpretation of section
Now,
54 EC is there, my lord. My lord, he has sold the paintings and thereafter, my lord, beyond the period of 6 months, my lord, he had invested, my lord. So, my lord, that is there, my lord. If your lordship will kindly consider, my lord. The questions are at page 11, paragraph 7.
Here is the case that, my lord, HSC, my lord, sold, my lord, the painting. Sold the painting. My lord, HSC's case is that, my lord, he, my lord, earned 1 crore. And rupees 90 crore, my lord, he earned 90 crore, my lord, 90 lakhs, my lord, he earned advance. 10 lakhs he earned thereafter, my lord. Now, my lord, when the, my lord, in the assessment proceedings, there was no agreement for sale. And the, my lord, when the, my lord, the CIT, my lord, used section 263, the HSC produced agreement for sale. That was not there in the, my lord, first round. And not only that, my lord, interestingly, my lord, if your lordship will count the day, first investment come within 6 months. The second investment admittedly come after 6 months.
No, tribunal has remanded the matter.
My lord, tribunal has not considered the, my lord, the point, my lord, lordship will kindly consider, my lord, here, my lord,
The EA was directed to examine and what was the sufficient cause before the SC of not filing this agreement during the assessment proceedings. And if such agreement exists, why the same was not mentioned in the sale bill. On the basis of explanation shall decide the validity of such agreement, then the date of the transfer for the purpose of computing LTCG.
yes.
Why are you aggrieved? How are you aggrieved by this order?
Yes, my lord. It was stated in the tribunal order, my lord, last paragraph.
Wanted back,
Para
but
nine
the,
also.
but the tribunal has not decided the point, my lord, whether, my lord,
Did not decide the point.
My lord, in my case, my lord, tribunal, my lord, allowed the appeal of the SEC.
Well, I have not received that copy.
In the result, assessment is set aside, restored back to the file.
yes,
No.
This is IT 70 of 20.
70 years, Puja
All
Agarwal,
are
yes.
same.
My lord,
my lord.
81, my lord, the 9 SEC instant maybe appeals are allowed. My lord,
No,
appeals
wait,
are
wait.
allowed.
Please give item 70, IT 71.
71, may I file? This Suresh Agarwal, my lord.
Puja Agarwal.
Puja to 70 first item.
71.
SEC stand allowed.
71 is a common order.
Yes.
All common.
All are common orders, my lord.
There are
Total 9
nine
matters, my lord, out of which, my lord, 2
No,
matters
no.
have already been decided.
IT 70 is a separate order.
My lord.
It is by a single member. Huh? No, it's a common order.
It's a common order, 9 matters, my lord.
9 matters together hard on 20th February 2020. Two already ordered passed by your lordship.
ওটা কি হয়েছে ওরা কি delay ground notice না delay ground notice এটাই
Oh, I'm sorry. I think I read the order passed by the commissioner.
yes sir. But first matter page 50 is the tribunal's order. If your lordship kindly sees page number 50, my lord, 50. In this matter, my lord, page 46.
No, according to you, the period should be computed from the date on which he received that 90 lakhs.
Yes.
But the full sale consideration was received only thereafter. The remaining 10 lakhs remained unpaid.
That case, my lord, made out by the my lord SEC before this my lord, Commissioner on Income Tax. Your lordship kindly see the my lord, the challan has been.
No, that was considered. That's what in page 55 of that is para 7, internal page 7 of the tribunal order.
Madam, may I subject to lordship correction, my lord? This second, when the my lord 10 lakhs rupees received, my lord, that period, if my lord 6 months, 6 month 180 days calculate, my lord, this second investment, my lord, admittedly come there later.
No, what is the prejudice caused to the interest of revenue?
Because my lord, they
There's
have
nothing.
yes, my lord, they have get the deduction of liquids, my lord, 50 lakhs. My lord, they said this is the capital, my lord, LTCG. But they have invested in 2014, my lord, perpetually after that.
See, they have received it on 2 dates.
Yes.
They made investment on respective similar 2 dates. So what is wrong? with
Last date, my lord, last investment, last date investment, my lord, admittedly, my lord, after 6 months. My lord, your lordship, kindly see the investment, my lord, 90 lakhs received on 7th August 2013. My lord, 10th lakh received on 19/10/2013. First investment made on my lord, 2nd 11/2013. The second investment made on 28th April 2014. My lord, that 28th April 2014 my lord, admittedly my lord, expiry of 6 months.
That's what the tribunal says. Page para 7, although the 4th line. CIT has made a sublime effort to support PCIT's finding that the relevant agreement dated 7/8/13 was nowhere examined during the course of assessment. The same is far from convincing, since the fact remains that PCIT has himself passed his order on merits after holding the assessee was not entitled for deduction under 54 EC, going by the very dates only. Then High Court decision, Delhi High Court, DG Housing Projects, distinguishes twin aspects of lack of inquiry and error in judgment at the instance of the AO, vis-a-vis 263. Once the assessing officer decides the case on merit, which is stated to trigger 263 mechanism motion, it cannot be held that the same is an instance of remitting back the matter to the AO in revision.
Here, Milord,
That is
here,
not-
Milord, our exclusive submission, where is the Milord inquiry? Milord, assessing officer, Milord, simplicity accepted the case of the assessee. Milord, the agreement which was never produced before the assessing officer, when the 260 proceeding has been invoked, thereafter, Milord, agreement has been issued. Not only that, your lordship kindly see the Milord page 53, the challan, the receipt, Milord, Rajnish Agarwal, the receipt says, Milord, normal course, Milord, the sale painting one, sale of painting 1 crore. Here is also not there. Milord, he has paid Milord advance money and 10 lakhs will be paid Milord thereafter. That is Milord also.
This inquiry has not been done, Milord, properly.
This is also in the ITT order.
I have not received that.
It is also in the ITT order. All order are same. All order are same.
It's common order.
I know that common order.
They have, Milord, the case of the assessee, Milord, before the tribunal, they said, Milord, by the English calendar month, Milord, the 6 month will be calculated after end of the month. When the month is.
Now, this agreement was produced before the PCIT.
Yes.
He has examined that.
Yes.
Where is his finding on the agreement?
Yes.
Yes.
Your lordship will,
Page 22 is the order under
Yes.
263.
Yes.
But that is also, Milord, page.
Your lordship is looking after Suresh Agarwal. Next matter, 71.
Internal page 5 of the Milord tribunal order had their internal page 5 of the tribunal order, Milord, after the Milord receipt, had there been any agreement between the assessee and the purchaser of painting as now produced before me, it would have been certainly mentioned in the sale bill, stating as being sale of painting as per agreement dated such and such. Absence of any such narration in the said bill, it shows that the agreement now being produced before me is doubtful in nature. Milord. That is his finding.
In the reply to the 263 notice, apart from raising the usual objection at page 26, internal page 5, during the assessment proceeding, all the details asked for by the learned AO have been duly submitted. In the said order, the AO has mentioned that in response to said notices, she so-and-so, FCA, so-and-so, of the assessee appeared time to time. Details and evidences were filed and books of accounts were produced, which were examined and test checked. The case was discussed with the AR of the assessee. Well established, the impugned order 143.3 was passed after calling for relevant information and after detailed examination. AO was passed as a matter after the verification of the evidence called for and also after due application of mind. No circumstances to be ordered to be termed erroneous insofar as prejudicial.
That is our.
Then, with regard to the merits, they have given this explanation.
Yes.
if this agreement was produced before the PCIT, he could have very well considered the correctness of the agreement. He could have tested whether it's a forged document, etc.
This is the case of the revenue that the agreement never produced before the assessing officer. First time produced when the 260th proceeding has been initiated. And immediately when the 10 lakhs rupees he got on 10th 19/10/2013 and second investment made on 28/4/2014. 6 months expired.
But from the date of receipt is what is, he has given 2 dates.
One date 7/8/2013. First 90 lakhs. Second 10 lakhs on 19/10/2013.
That was when the second installment was
First
received.
paid. First investment made on 2/11/2013 within 6 months.
Correct.
Second investment made 50 lakhs on 28/4/2014. This is after expiry of second installment, that is 19/10/2013. Admittedly 6 months after 6 months.
Yes. Their contention is
the calculation should be made in the British calendar year after the 6 months. They are calculating that the October, month of October, that cannot be calculated. Months could be calculated after October, November, December, January, February, March, April. That is the
no in the instant. Therefore, they say in the instant case, the date of transfer would be 19/10/2013, and the time limit for investment in REC bond would be 30th April 2014. First investment of REC bond was made on 1/11/2013.
Yes.
After getting the final consideration, the second investment REC bond was made on 29/4/2014.
Yes.
That is 1 day before the cutoff date, 30/4/14. That is their contention.
That is their contention.
900 and odd days.
Lordship,
is the interpretation, your lordship.
And
900 days, your lordship kindly
Out of
consider
9 matters, 2 have been dismissed by my lords.
9 matters that
Same tribunal's order.
Oh, out of 9?
Yes.
2
I
have been
have
dismissed. I've
given
given 2 orders.
This is IT 8075.
Another elaborately, your lordship has given the
your
judge
lordship,
order.
your lordship kindly consider when the order
Why the other legal heads should suffer? 2 of them have got.
The same order.
the tribunal order passed in the
After
month
all,
of
they got some painting from their forefathers. They sold it for 1 crore, out of which you have already taken off this money in deposit. The remaining 5-6 legal heirs would have partitioned.
Because lordship has given order on 28 March.
days count
Mridul Agarwal.
days counting 900 days but the order your lordship knows order passed on March 2020 and the COVID starts June 2022 we get the exemption 9 months delay only 270 days
No,
delay.
my lord.
Yes, if your lordship
More than
correctly,
900
if the COVID period is left, not 270 days only.
Page 16, para 20,
Content,
my lord.
the contention of the
this-
tribunal is not
this
correct.
asset, this painting was declared under the VDAS in as early as you see that, and it has come generations after generation.
Parent order is 28.
They shouldn't result as if they have inherited a sin and get caught with the department. These appeals have been filed. Please take down, sir. And by the revenue.
My lord, I have not received the.
You get it from him, madam.
My lord, I'm giving.
Madam
I'm giving.
These appeals have been filed by the revenue under section 260 capital A of the Income Tax Act 1961, challenging the order dated 28th February 2020, passed by the Income Tax Appellate Tribunal, C Bench, Kolkata, in a batch of 9 matters, all pertaining to the assessment year 2014-15. And all the respondent assessees are members of a joint family. The first hurdle the revenue has to cross is to convince this court as to convince this court with acceptable explanation for the delay of 974 days in filing the affidavit, in filing the appeal. We have perused the affidavit filed in support of the condoned delay petition, and we find that the usual reasons have been set out, stating that the appeal papers had to be stating that the file had to be circulated to various authorities until a decision, final decision was taken for filing the appeal. And it stated that on account of the COVID pandemic, things couldn't be taken forward and there is a delay in filing the appeal. And for such reason, the delay of 974 days has to be condoned. Similar plea was raised by the revenue in one of the appeals filed before this court against one of the orders passed by the tribunal, which is a common order, in IT 75 of 2023. And after elaborately hearing the submissions on either side, the application was dismissed by order dated 28 March 2023. The order reads as follows. Please quote this order. Subsequently, another appeal was preferred in IT number 76 of 2023, which is also one of the appeals covered in this batch, and the same was dismissed by order dated 5th April 2023. In the light of the stand taken by this court in the aforementioned orders, a different approach cannot be maintained in these cases. Thus, in the absence of any satisfactory explanation for the inordinate delay, we are not persuaded to exercise any discretion in favor of the appellant revenue. Accordingly, the applications are dismissed and consequently the appeals stand rejected and the substantial questions of law suggested are left open.
Grateful.
Grateful.
It's a common order, 127.
Item number 8 and 9 for admissions.
Yes.
Lordship, in this matter, we've not done supplementary affidavit. Lordship, we gave leave to file the same.
You are filing supplementary affidavit.
Your Lordship, it shouldn't be ideally in the form of a supplementary affidavit, but since I filed a cross objection, my intention is to file an affidavit in support of the same, Your Lordship. Just to bring the documents on record.
No, we didn't get you.
Your Lordship, I filed a cross objection, Your Lordship. Item number 9 is my cross objection.
Yes, OCOT.
I intend to bring on record the documents, Your Lordship, so as to support my cross objection. I've already
So
filed.
this can be by way of a compilation in the cross objection. You have put it in the form of
an affidavit, Your Lordship.
Copy has been given.
Yes, sir.
My Lord, in this case, my Lord, the SSC's case, my Lord, was selected for scrutiny, my Lord, under the computer-aided selection scrutiny system. Lord, one of the criteria was a large specified domestic transactions, my Lord, which is, my Lord, a transfer pricing parameter. Now, my Lord, in terms of section 92CA, my Lord, which has been later on, my Lord, elaborated by the CBDT instructions, my Lord, it was mandatory on the part of the assessing officer to refer the matter to the transfer pricing officer, since one of the criteria for scrutiny was a transfer pricing parameter. My Lord, he did not do it. Therefore, my Lord, the commissioner, my Lord, exercised his jurisdiction under 263 and revised the order, saying that you complete the exercise de novo because you have not adhered to the mandatory directions under section 92CA. Now, that was challenged in appeal by the SSC before the tribunal. Before the tribunal, only one ground was pressed. The ground that was pressed was that section 92BA, clause 1 of that section was omitted by an act of parliament. This omission amounts to deletion to such an extent that it means effacement of the provision from the statute ab initio, as if it was not there at all. Therefore, even prior acts, my Lord, which are hit by section 6 of the General Clauses Act will not be covered. It will not amount to an appeal. It will amount to a deletion, as if this provision never existed. And Lord, the tribunal held in favor of the SSC And Lord, against that, Lord, we are in appeal before your Lordship. Lord, this is the only point in our appeal. Lord, my learned friend's cross objection, Lord, he has taken a point that, Lord, the specified domestic transaction in respect of the associated entity, Lord, he has been taxed. Lord, therefore, the entire exercise is tax neutral, as far as I can get, Lord. Therefore, Lord, he wants to cite that, Lord, this was not a point which was raised before the tribunal. Lord, it was not pressed
But,
before the tribunal.
oh, not pressed before.
Not pressed before the tribunal. I can show it from the memorandum of appeal, Lord. The grounds, Lord, which were taken in the memorandum of appeal, Lord, have been quoted by the tribunal in the order.
But some finding has been rendered by.
No. That point was not discussed at all. Because, my Lord, the tribunal holds at least at 2 places that this was the only point urged by the learned advocates appearing for the assessor.
Your Lordship, if I may submit, Your Lordship, what has transpired is that, Your Lordship, 263 proceedings were initiated against the assessee. Your Lordship, before the Commissioner of Income Tax, the assessee duly made submission of certain issues. Firstly, that the order passed by the assessing officer is not erroneous insofar as prejudicial to the interest of the revenue, on the grounds that firstly, the assessing officer had conducted due examination of the issue by calling for a Form 3C EB. I had duly filed the same. The issue before the assessing officer was specified domestic transaction, and that he had looked into it by calling for Form 3C EB. Subsequently, the assessing officer, on the basis of the documents I furnished, issued a 133(6) notice on the related associated enterprise. The associated enterprise duly confirmed the transaction, provided the details of the transaction, Your Lordship. And both the entities, the assessee as well as the associated enterprise, were both being taxed at the maximum marginal rate. So, Your Lordship, in any event, this entire exercise would have been tax neutral, or it could not be said to be prejudicial to the interest of the revenue, because, Your Lordship, both the entities are taxed in India and are being taxed at the maximum marginal rate. Because, Your Lordship, the entire basis of bringing in the provisions of transfer pricing was to prevent transfer of profits from one jurisdiction to the other. And Your Lordship, that was also the one of the reasons.
Omission of clause I, that is not considered by any other court.
Your Lordship, that's been considered by the Honorable Karnataka High Court. This issue was decided in favor of the assessee. SLP has been preferred by the department, and that SLP is pending before the Honorable Supreme Court.
Pending.
And Your Lordship, if I may fairly submit, this issue has come up before my lords on 2 separate occasions. One is a entity in which the common order has been passed in case of this assessee. The other entity, Your Lordship, my lord was pleased to admit the appeal. And in another matter, Your Lordship, also the same issue has been raised, and even that has been admitted by this Honorable Court. So, Your Lordship, as far as the department's issues are concerned, that has been admitted. Now, Your Lordship, as far as the assessee submissions before the tribunal are concerned, Your Lordship, the assessee made submissions which go to the root of the matter and go into the fact that the assumption of jurisdiction of 263 was incorrect. The assessee made these submissions that the entire order passed by the assessing officer was after due examination and was not prejudicial to the interest of the
That was
revenue.
not considered.
That has not been considered by Commissioner of Income Tax Appeals. The assessee made another submission, Your Lordship, which is very interesting. Your Lordship, that has not been adjudicated upon. Your Lordship, that is that the direction given by the CBDT, first of all, that the assessing officer was not required even under the the circulars issued by the CBDT to make the reference to the transfer pricing officer. But nonetheless, Your Lordship, the reference to be made to the transfer pricing officer is under section 92CA, which is if the assessing officer considers it necessary and expedient to do so. However, under section 92C, the assessing officer himself is empowered to examine the transaction. So, Your Lordship, by the circular, the department cannot render section 92C OTOs. And nonetheless, Your Lordship, this by the circular, the department is entering into the discretion conferred upon the assessing officer under the statute. Your Lordship, although not in so much of detail, submissions were made before Commissioner of Income Tax, but nonetheless, these 2 issues were also raised. The Commissioner of Income Tax, Your Lordship, in one single paragraph, he simply goes into this argument of that no reference was made to the TPO, and therefore the order passed by the assessing officer is erroneous insofar as prejudicial to the interest of the revenue. He doesn't go into the aspects of the other submissions made which deal with the jurisdiction, assumption of jurisdiction. Now, Your Lordship, before the tribunal, the assessee in the memorandum of appeal, Your Lordship, has raised the issue that the order passed by the assessing officer is not prejudicial to the interest of the revenue. A specific ground has been taken that the order passed by the assessing officer is not erroneous. And thirdly, another ground has been taken, which is a cumulative ground that it is not erroneous insofar as prejudicial. The grounds of the assessee has been reproduced in the order passed by the tribunal. Your lordship, now before at the time of the hearing, your lordship, this very issue had already been adjudicated by the tribunal in 2 other appeals. Your lordship, they haven't come before this honorable court, but in 2 other matters, the same issue had been decided in favor of the assessee. Your lordship, so therefore, at the time of hearing, your lordship, it was limited. The arguments were limited to this one technical ground, because your lordship, if this ground goes, then if this is adjudicated in favor of the assessee on the basis of existing decisions of the tribunal, then your lordship, the other issues need not have been pressed. But your lordship, nonetheless, my humble submission is that your lordship, the issue of jurisdiction can be raised at any stage, because the Honorable Supreme Court has held that jurisdiction can be classified into 3 categories: territorial jurisdiction, pecuniary jurisdiction, subject matter jurisdiction. Territorial jurisdiction and pecuniary jurisdiction have to be raised at the first opportunity possible. But subject matter jurisdiction can be raised at any stage. And nonetheless, your lordship, there's no estoppel against law.
So therefore, you would like a finding as to whether in all such cases, an automatic reference to the TPO is required or.
Yes, your lordship, that would be one. Second is that it is not erroneous insofar as prejudice.
All right, we'll admit this appeal. Your cross appeal also, let it come along with the appeal.
I know.
Huh? We have heard so also. Appeal is admitted on the following substantial questions of law: 1, 2, and 3, page 6. The cross objection is also entertained and just directed to be tagged along with the appeal. Since all material papers are in the stay petition and in the annexures filed to the supplementary affidavit in the cross objection, the same shall be treated as an informal paper book, and filing of informal paper book stands dispensed sometime in July.
A similar matter wherein your lordship, these issues. And the other matter, your lordship, is the first matter. My learned friend, your lordship, is providing the copy. That is Srinathji Steel.
Raipur. That is Raipur Steel.
Your lordship, this is Raipur Steel.
Was decided along with Srinathji, my lord.
Yes.
Sort of, my lord.
Oh, this is, but cost title shows Raipur Steel.
Your lordship, this is Raipur Steel, your lordship. But Srinathji was the other matter which was adjudicated by the ITAT.
Also admitted, my lord.
That has also been admitted, your lordship.
List this appeal along with ITAT number 234 of 2022 and ITAT number 41 of 2023 in July, the monthly list of July.
I'm grateful, your lordship.
Item number 10.
Not 10, my lord, I would like to devote some more time, my lord.
My lord, my humble prayer is to let it be posted after summer vacations.
As jointly prayed.
My lord, may I submit the opposition?
June.
My lord, one more request, my lord. My learned friend's name, my lord, does not appear, my lord, in the earlier order, my lord. He is appearing.
In the previous matter?
Yes, my lord. In this matter only.
All right. You please include this.
8th February, my lord.
In the order dated so and so, along with Mr. It is there, Amit Sharma. It is there.
8th February, my lord. 8th February.
In the order dated 8th February 2022, along with Mr. Om Narayan Rai, the name of Mr. Amit Sharma shall also be included and necessary correction be made. And this order shall form part of the order dated 8th February 2022.
After vacation.
Item 10 at the request jointly prayed. After vacation, you give a date.
Grateful.
Item number 11.
My lord, this matter, my lord asked us to make a compilation. I have made. Manasi has not come today with a compilation. That's my difficulty, my lord. Kindly keeps it next Monday, my lord.
But you have to serve Mr. Bhumik.
I will do that in the which is why my lord keeps it on Monday.
Next week.
Next week, anytime.
The time for filing compilation is extended by a week. Advance copy be served on the learned advocate for the respondent.
We'll do that.
list on so and so date.
Because there are number of documents. Actually, there are 5 orders, 5 show cause notices, 5 replies to this part, which is the reason it took little more
Then
time.
we'll have it after 2 weeks so that
My lord,
you can go.
only it is only, they have revoked my license on the basis of CVLR Act, my lord, and the order of the tribunal is
Then
very
let it
clear.
come after 2 weeks. Yes. Next.
My lord.
Item number 12.
Weeks? 2 weeks. This is my my application, my lord. Copy extra check. For Dr. For Atifa. My lord, I made a very short list of dates for this matter. Yes. I'll give you a copy. এটা কেটে দিতে হবে। কোনখানটা কাটলে আছে? কাটলে বলুন না।
No, this list of dates. Here it is.
will provide items to benefit support.
Oh, nice. You want to, yeah. That's okay.
That 16 is the file.
Yes.
My lord. My lord, this is mainly on the interpretation of the definition with regard to input services. Whether the Coke project that was commissioned by the SSC, whether it's a modernization project or whether it's a new project. Now, my lord will kindly straight away come to the tribunal's finding, my lord. which is judgment starts from page 74 of the stay petition. My lord will kindly take paragraph 10 first at page 79.
Yes.
My lord will kindly see in paragraph 10, we have examined the rival submissions. For better appreciation of the issue involved, it would be appropriate to reproduce the definition of input service. Now, input service has been defined. My lord will kindly see here, input service is in 3 parts. My lord, which includes also an inclusive part as well as an exclusive part, which excludes. My lord will kindly see, may place 2-1. Input service means any service used by a provider of taxable service for providing an output service, or used by a manufacturer, whether directly or indirectly, in or in relation to the manufacture of final products and the clearance of final products up to the place of removal. Now is the part which affects us, and includes services used in relation to modernization, renovation, or repairs of a factory, premises of provider of output services, or an office relating to such factory or premises, advertisement or sales promotions, etc., etc. I'll not go into that again.
But
My lord, we come to the last line, but excludes services which are specified here in A and B. One is specified in subclause P, Zn, ZZL, ZZM, ZZQ, ZZZH, and ZZZZA of clause 100, which is relevant to our case, my lord.
Insofar as they are used for A and B.
My lord.
So the
Insofar as they
exclusion specified clauses
are
will
these.
be restricted to these 2 categories.
Yes, my lord. Yes, my lord.
Inclusion will be modernization, renovation, or repairs to the factory.
So now they are saying that it is modernization and therefore it is included.
It's the coke plant.
Coke plant, coke oven plant, a new plant. They have constructed where foundation have been laid. Now, my lord, my lord allows me to.
Yes, yes, please proceed. Please proceed. As you.
Construction of a building or a civil structure or part thereof is an exclusion, or laying of foundation or making of structures for support of capital goods, except for the provision of one or more of the specified services. So, my lord, our contention is, his is a new project. It is not that he has replaced any machines. No replacement machines are there. A completely new project has been started. Foundation has been laid and civil construction has been made. And he has taken works contract service from 5 separate companies, for which he has paid works contract tax also. For civil work, my lord. And he has paid service tax. Thereafter, he has taken Senvat credit and paid central excise duty in lieu thereof. Now, my lord will kindly see page 81, the last paragraph. Is my lord with me?
Yes.
ZZZZA says to any person by any other person in relation to the execution of a works contract, excluding works contract in respect of roads, airports, railways, transport terminal, bridges, tunnels, and dams. Neither of them are there. Explanation. For the purpose of this subsection, subclause, works contract means transfer of property in goods in the execution of such contract is leviable to tax as sale of goods, and such contract is for purposes of carrying out erection, commissioning, or installation of plant, machinery, equipment, or structures, whether prefabricated or otherwise, installation of electrical and electronic devices, pluming, draining, or other installation for transport of fluids, heating, ventilation, or air conditioning, including related pipe work, duct work, and sheet metal work, thermal insulation, sound insulation, fireproofing or waterproofing, lift and escalator, fire escape staircases, or elevators, or construction of a new building, or a civil structure, or a part thereof, or of a pipeline or conduit, primarily for the purpose of commerce or industry. So this is This is the
But the
definition,
specific case of the SSC is that
my lord.
they have supplied all these goods to the contractors. And there is no transfer or sale of any goods to the appellants on the basis of which VAT or sales.
My lord,
tax. That is the
from
specific-
where this finding has come, my lord will now allow me to show that, my lord. My lord will now straight away come to page 85. So till now, the sections were placed. Section 85 straight away goes to para 15 is the expression works contract. This is the definition of works contract. I'm not going into it at the moment, my lord. Now straight away comes to paragraph 16. We find that the definition of input service has an inclusion clause and an exclusion clause.
Correct.
The intention of the government could never have been to cover certain services in the inclusion part and at the same time cover them also in the exclusion clause. The cases cited by the learned advocate for the appellant support this view. The expression modernization, renovation or repairs of a factory was appearing in the definition of input service. Both before and after 1st July 2012, it had not been denied by the department that the co-covent It has not been denied by the department that the co-covent project of the appellant was towards modernization, renovation of the existing plant. This is incorrect. It is an absolutely incorrect finding that has been made that there is no denial by the department. That my lord will now see thereafter 3 judgments have been referred on the basis that I have not denied that this is not modernization. Thereafter, all the 3 judgments, Reliance, Iron, Malay, Bombay Market are all factually different completely. Now, my lord, will kindly see the board's instruction. They have also relied on the board's instruction. My lord, is at page 88. They have relied on the board's circular.
Which says that credit on input services used for repair and rental is allowed.
My lord, for what? Credit of input services used for repair or renovation of factory.
In
Or
fact,
is allowed.
assessee's case, as could be seen from the grounds of appeal, services availed by the appellant from the service providers like Thermal System, Gannon Dunkley, Marina Projects, Rafiq Engineering, MR Enterprise, were for the purposes of fabrication, erection and commissioning of different aspects of the co-covent project in the factory premises of the
completely new project.
Undoubtedly, some civil, electrical and
No, my
other
lord,
works had to be done. All of a sudden a
No, admittedly, it is a new project completely. Now, look, my lord will kindly see the order.
Record, sir.
My lord,
If at
kindly
all,
my lord,
then
kindly
you should agitate that before the tribunal.
No, it has. My lord, kindly sees the order. Because the tribunal has not looked into the facts and circumstances that have been specifically dealt
That
with in the
appears to
order.
have not been disputed by the revenue.
No, straight away they come to a conclusion that revenue has not disputed, my lord. It's an incorrect finding. How will I just give up my case that this is not for modernization? Once if I accept it is modernization, therefore there is nothing left then. My lord will now kindly see the order, which is at page, the adjudication order, which is at page 28.
Discussion finding for 36.
And the relevant page is at page 36. My lord kindly allows me to place those portions and my lord will then be able to. Capacity application. My lord, will kindly see page 36 onwards, the discussion and findings.
But before that, you see what was the allegation in the show cause notice?
My lord.
Page 29. He said SSC are alleged to have taken credit on service tax paid, services rendered by thermal so and so, etc.
Yes.
The nature and extent of service provided by the above service provider, such as construction of structural support and laying a foundation for capital goods, come within the purview, under the purview of works contract.
Yes, my lord.
During the period so and so, the assessee were found to have taken credit. This is what they have said.
Yes.
Their reply was, they have specifically stated,
At page 33 and 34.
Hmm.
This is the sum. My lord, he contradicts his own stand. My lord will read this and then see the next page. First, he says it's not a works contract. Then later he says that part of it is works contract. My lord will kindly see page 35,
no,
second
their
paragraph.
specific stand from the beginning was, the notice submits that they have not received any works contract service and no services were used for construction of any building or civil structure or for laying a foundation or making structures for support of capital goods, as was evident from the bills and invoices on which credit was taken.
My lord, thereafter. Next paragraph.
Rents, services, fabrication, erection, manpower, maintenance are not excluded from the definition of input service, because that exclusion is only in category A and B.
My lord continues after that. My lord.
The notice further submits that above services, including construction service, in some cases works contract service,
In some
were used in relation to modernization, renovation or repairs of the factory. Fact of which were kindly verified by the learned by causing verification.
Now kindly seize the order.
They have submitted the relevant bills. It is up to you.
Now, my lord,
you brand the entire thing in this, paint it with the same brush. That is wrong.
no, it is which is why my lord will kindly see the discussion and finding and how it has been branded that way.
He has done some painstaking exercise, seeing the bills, etc.
All the bills have been put in here in the discussion and findings also, my lord.
No question of law.
My lord, question
No
of law.
substantial question of
Question of law. Perversity, my lord. My lord, here there is clear perversity where
they are a steel plant.
yes, lord. They are steel plant, but they have made a coke oven project, separate coke oven project.
Because we did one matter. Manasi only argued that. That is also, it forms part of a steel plant. Whatever comes out of that can be sent to the coke oven plant, and then impurities removed, etc. A lot of things. In fact, we
No, that my lord was
that.
my lord was what similar stand was taken in Reliance. My lord will kindly see Reliance how they have.
There's no question of law, Mr. Kondale.
My lord, Reliance facts
And
are completely
circular
different.
of the board has been followed. What
Yes,
is
yes, Milad, I just want to this is one
No,
thing.
no, board is not, that is not applicable in this facts and circular.
No, just one thing, one
At
comment.
all. My lord allows me to finish the discussion and findings and then my lord take
Okay,
a
okay.
view. My lord will kindly see page 36. My lord, I will not trouble my lord with the initial part. I will straight away go what the SSC has contended, which is at page 38. He said SSC have contended that to quote, My lord, this is the part that I placed a little while ago. I would like to reproduce some portion of letter of intent, LOI number so and so dated 10/6/2011. Issued to Messrs. MR Enterprise for civil work of LRF, furnace area at Coke Oven of Jai Balaji Industries, Durgapur, West Bengal. Scope of work.
Yes.
The scope of work under this LOI is as follows. My lord will kindly see the scope of work. Earthwork, excavation, filling with earth or concrete, shuttering, reinforcement, masonry work, etc., my lord, which all deals with the foundation, my lord. Similar scope of work is described in LOI number so and so. Dated so and so, issued to Messrs. Rafik Engineering and Gannon Dunkel, respectively, for civil work of Coke Oven, non-recovery type project as Jai Balaji Industries, so and so. From the description of the work as described,
yes,
both the LOI issued by the said SSC, it is evident that the contracts were awarded purely for construction of civil structure. It is clear that the documentary evidences are in stark contrast to what has been said by the SSC in their defense. Thus, the SSC have miserably failed to establish their case. Thereafter, my lord, but this has not been dealt with at all by the tribunal. Tribunal straight away says that we have admitted that it's a modernization thing. Now, my lord will kindly see the next paragraph. The said SSC have categorically stated that they have not received any works contract service. In this connection, I quote the definition of works contract. I'm not troubling my lord with this. Last paragraph. From the above definition of works contract service, it is clear that the element of sales tax in the contract is an essential criteria for deciding whether a service can be classified as works contract service. Works contract tax, which is nothing but TDS of sales tax, can also be levied in lieu of sales tax in the execution of any works contract service. Thus, if VAT or WCT is involved in a service, the service can be termed as works contract service. From the copies of bills placed before me, I find that in the bills, WCT has been deducted by the said SSC, which confirms that the nature of service conforms to works contract service. Specimen copies of such bills are given below, my lord. Now, my lord will see in this 2%. My lord will kindly see item number 5. My lord is with me. Item
Yes.
number 5 is works contract tax at 2%. My lord will next see the next paragraph, the next bill, which is MR Enterprises. My lord will kindly see what is the nature of work, which is just below MR Enterprises, memorandum of payment, Balaji, MR Enterprises, and then civil work of Coke Oven project.
but assuming it was a works contract,
Yes, ma'am.
will it fall within the exclusion? That's the point.
Yes.
His case was fabrication. What is it? Erection and commissioning. Installation commissioning, which will not, if you read by the plain language, it's pure construction of building or a civil structure, laying foundation stone or making of structure for support of capital goods. But if it is a composite contract, there may be certain issues or the scope of work may contain a works contract service. But unless you will have to specifically bring them under either A or B or A and B for it to be excluded. That's exercise done by the tribunal and it finds that it cannot be brought.
My respectful submission is that exercise has been done by the adjudicating authority, not by the tribunal. Tribunal has not specifically dealt with anything with regard to the exercise undergone by the adjudicating authority. That's my respectful submission, my lord. And I will again show that the tribunal's order on that, my lord. My lord will now, can you see the third bill? That also is the same, Gannon Dunkley. Now, my lord, I'll place 2 or 3 more paragraphs. Thereafter, my lord, I'll take my lord back to the tribunal's order. My lord, 43. Besides, I find that the rule 9(6) of the central SENVAT credit rule stipulates that the burden of proof regarding admissibility of SENVAT credit shall be upon the manufacturer or provider of output service taking such credit. Thus, in this era of self-assessment, the onus of taking legitimate SENVET credit lies on the SSC in terms of the aforesaid rule. I'll place rule 961, which means before taking credit, SSC had to ensure its inadmissibility. In the present case, I further find that despite knowing very well that the services in respect of which they had availed SENVET credit were availed in contravention in statute provision, not having been used in or in relation to manufacture final products, the SSC intentionally availed the SENVET credit of the service tax paid on such services. This clearly proves the malafide intention. My lord, will next see the next paragraph. This is on the suppression part, etc. Now, my lord will kindly see the three judgments that have been referred to by the tribunal. And I have in my grounds, my lord, I will kindly see my grounds. Para 10.
Page 10.
My lord kindly takes para 10 of my state petition. Page 10 of my memorandum of appeal, my lord. My lord, these are the 4 judgments which have been relied upon by the tribunal to come to this conclusion. My lord, without actually going into the fact, there is no specific discussion on the facts, my lord. But we'll kindly see para 21. Para 20 are the 4 judgments. I have differentiated the 4 judgments, my lord. For that, in the case of Reliance Industries Limited, relied upon by the learned tribunal, the project was nomenclature by the appellant as the 13 project. The erection, commission, installation service and works contract service in dispute were rendered under 81 contracts by 41 contractors and service providers. The appellant has not availed any credit in respect of services used for laying of foundation or for making of structures for support of capital goods. In that case, he had not taken any credit for that, my lord. The only credit on fabrication of structures that has been availed by them in respect of pipes supports to the tune of rupees 33 lakhs, or as the said pipe supports are themselves regarded as capital goods as per the definition of capital goods under rule 2A of the SENVET credit rules. Being pipes or tube fittings. Likewise, the appellant has also not availed any credit on construction service or works contract service insofar as they are used for construction or execution of works contract of building or a civil structure or a part thereof. This is not the case in this case, my lord. In this case, he has taken complete benefit. He has taken the SENVET credit on everything that was.
I don't think so. It's actually correct.
No, that is true. My
No, here come to page 66.
Page 66.
After 14, they say about clause 2 as two subparts. The para 15. Applicant has given details description of the process followed in laying of the pipelines, including site preparations as also. Observe both the aforesaid service to be excluded from the scope of input are to be used for support of capital goods. There is no doubt subject goods are pipe value or capital goods, but the input services to be rendered by the applicant is not for support of pipes and valves, that is capital goods, but for laying of pipeline for transport of gas.
Yes.
As input service received from the applicant from EPC contract others is not for laying of any foundation or making any structure for support of cal, same will not fall under the exclusion clause. Then they rely upon the mark exhaust system judgment over the page.
Yes.
After referring to the show cause notice which you have just referred to, para B15. Department has taken all the above services as being work contract service.
Yes.
Nature of service provider is determined by the service provider or the jurisdictional central excise officer at the end of the service provider, not the recipient. It is not legally permissible of the central excise officer of the receiver's end to change the classification. They have never admitted that. And
This is a quotation of the other judgment, my lord.
No, this is my ground. This is my.
His ground.
Their
is-
grounds, their
This is an
grounds.
alternative ground, my lord.
Is an
I'll
alternative
come to
ground.
the
yes.
main ground. Let him finish, my lords. They may not be at all. Let him finish.
Because he has gone into that.
Yes, sir.
And then based on invoices, they've given an explanation in
Yes.
para B16.
Let him finish, my lords. I'll just short point. I'll cover all his points as raised.
On
Let
the
him finish.
basis of invoices raised by the service provider, only 9 cases relate to works contract service. He says.
These are the
Involving credit
alternative
of so and so as per annexure A to the show cause notice, as per annexure B to the said show cause notice.
These were my alternative.
Therefore-
plea. These were my alternative. pleas.
Well, but that has not been looked into by the tribunal.
Okay.
It's an alternate, even if it's an alternative plea, he himself is admitting that there is a works contract. Tribunal completely gives a go by. Tribunal says that I have admitted that it is a modernization thing and based on 4 judgments. And my lord allows me to also differentiate the other 3 judgments.
Page 11,
Page 11, my lord.
Ion Exchange India,
Yes, my lord.
engaged in the manufacture excessive
Brief
goods.
facts of the case are that the appellants are engaged in the manufacture of excisable goods falling under chapter 39 and availed Senvat credit of service tax paid on construction service, modernization, renovation and repair service of the existing plant and machinery in their factory premises so as to meet USA FDA guideline. So this was an existing factory. To ensure that USA guidelines are adhered to, this had been done. So that was a part of renovation, modernization and repair. Now, Ion has also been referred to by Reliance. Now, my lord, the next one, Male Engines.
That is painting, painting of
Yes,
factory.
that is painting. Nobody is stopping them from doing that.
Then Bombay Art Silk is recarpeting of road.
Right. So nobody, if they had done these things, there was no cause for me to come in between, my lord. No, my lord will kindly come back to the tribunal's order, the judgment, impugned judgment. My lord sees from page 79 again. From page 79 again, what the tribunal has. Tribunal has from paragraph 10 said, we have examined the rival submissions. Thereafter sets out the definitions, which goes on till paragraph, till page 85, my lord.
Yes.
Now, thereafter, the tribunal goes into the judgments. Now, allows me to kindly place this part. We find that the definition of input service has an inclusion clause and exclusion clause.
Okay.
The intention of the government could never have been to cover certain services in the inclusion part and at the same time cover them also in the exclusion clause. The cases cited by the learned advocate for the appellant support this view. The expression modernization, renovation or repairs of a factory was appearing in the definition of input service. Both before and after 1/7/2012. It has not been denied by the department that the co-government project of the appellants was towards modernization and renovation of the existing plant. Now, my lord, he goes on to
Now the 4 judgments you have distinguished.
and my lord,
Fourth
see
circuit.
what the judgments are saying.
And appellant has correctly taken credit.
That's it. Where is the finding?
Appeal alone.
Where are the facts? Nothing
Yes.
has been gone into. And another aspect that they have very vehemently argued in the beginning, my lord, will see that they say that the period, part of the period, about 6 months were earlier than July 2012.
Negative list.
Now, my respectful submission is there is no change. There is no difference in the two definitions.
But that aspect tribunal didn't go into it.
That aspect tribunal did not go.
Yes.
Yes, Manoj. Manoj, I'll just invite your attention to part of the order in original itself, page 34. These submissions, which my learned friend just read out also.
Yes.
The point was we had been saying all through that what was involved was modernization, renovation and repair. Because when you modernize, some renovation involved, some repair, consequential repair is also involved. I kindly see there were 3 show cause notices issued to me, Manoj, and all the 3 show cause notices were identically worded for different periods. And my reply was also more or less identically worded. So this has been reproduced by the learned adjudicating authority.
At page 35, my lords. The second para. It is also submitted that rent services, fabrication, erection charges, manpower services, repair and maintenance are not excluded from the definition of input service. The notice further submit that all the above services, including construction service and in some cases works contract service, were used by them in relation to modernization, renovation or repair of the factory. The fact of which may kindly be verified by the learned adjudicating authority by causing verification in this regard. Well, we made these submissions before the adjudicating authority and we also requested that if you have any doubt, kindly verify. This was not verified. So the obvious conclusion is that he has accepted it, that my project was consisting of modernization, renovation and repair. This has been accepted. Now, this is a matter of fact. Now at the appeal stage, second appeal stage, this is not appropriate for them to go into the question of fact, and because the tribunal is the last fact-finding authority. Having found that this is a modernization, renovation, repair project, now it does not behove them to hold otherwise, having that has been established. Further, without going into the different judgments cited by lords, the board circular is very clear. So my project was for modernization, renovation, and repair. And the board circular, my lords, is very clear. Page 88. The question raised was in the board circular regarding input services, whether they are available for repair or renovation or not. And they've categorically said that it is covered in the inclusion clause and it is covered. So since my case was modernization, renovation and repair, board clarifies that it's covered in the inclusion clause. Now they can't be held to be arguing against the board circular. The department can't be arguing against the board circular.
In the show cause notice, it was never disputed that it was not a renovation, not a repair.
Exactly.
What they said was the services which you are availed falls within the exclusion.
Yeah, kindly see the, I'm glad, Bilal, kindly see what the show cause notice says. This one of the show cause notices, all are identically worded. What was the main? I'll kindly come to page 19 straight away. What was their view? What was the view they were propounding? Para 2.3, my lords, page 90.
Yes.
In terms, this is the allegation show cause notice. In terms of provision of Rule 2L, services provided under the works contract services have been straightaway excluded from the ambit of input services, and hence it appears that the appellant, it appears that available in such case is not admissible. At all admissible. So here is saying, what they are saying is provided under the works contract services have been straightaway excluded. So they're not making any exceptions. They are saying if it is works contract, it is excluded, which is factually not correct. Even their own submission is that only certain types of works contract are excluded. So the whole case is based on wrong presumption, wrong understanding of the law. And the whole case is built up on that. Now they can't be improving this at that stage, that what we meant was something else. The whole case, kindly see this third show cause notice also, my lord. All were identically worded at page 25. 26 rather, para 2.3. In terms of provision of Rule 2L, services provided in the works contract services have been straightaway excluded. So it is not that certain types of works contract excluded, all works contract excluded. And then they say a subset of that is laying the foundation, etc., etc. You are involved, therefore you are out of it. So the main ground they were arguing was that works contract itself is out of service.
That's not the.
That is not the.
2L is not that way.
And 2 is not that.
But
2A only says for construction or laying the foundation. Only certain types of works contract excluded. But the understanding of the department at that point was that works contract straightaway excluded. Apart from this, my lords, the judgments which I shouted, my learned friend has selectively quoted from them. Kindly see what the judgment says. Well, in this context, I'll just give the judgment, the whole, all the judgment, because they were just extracts have been produced. I'll just, because instead of relying on this, on the extracts only. Well, the first judgment is of Reliance Industries. I'll not go through the facts, but Leonard has already reproduced. I'll just kindly come to page 48 straight away of this compilation of judgments. 47, page 47, my lords. What the tribunal holds.
Yes.
Without prejudice to above findings, we further find that the appellant's factory is admittedly a huge existing petroleum industry and working for decades. The ECIS service, that is erection, commissioning and installation service, was used for expansion, renovation and modernization of overall existing petroleum plant. Same as my case. As per the inclusion clause of the definition, that services related to modernization, renovation is an admissible input service. In our view, even though service of construction of building or civil structure are falling under the exclusion clause, but even if similar service is used for renovation and modernization of existing factory, the credit is admissible. The exclusion applies only in respect to such services as specified therein, which are used for initial setting up of the factory. And the reason behind it, my lords, is this definition of input service was amended on 1/4/2011. The position which was there before 1/4/2011, my lords, kindly see in my compilation at seal number 6 at page 71. At page 72. This was the position definition input service before 1/4/2011. My period is after 1/4/2011. So what was the position before? That is on 2L, clause, subclause L, input service means any service used for providing taxable service for providing output service or used by the manufacturer, whether directly or indirectly in relation to the manufacture of final products and clearance of final product of trace removal, and includes services used in relation to setting up, modernization, renovation, or repair of factories. If you see the definition after 1/4/2011, why I have mentioned this was initially input service was allowed even for setting up. That means even if you're constructing a new factory, input services were allowed as credit. Now, 1/4/2001, the government took the decision, constructive decision, to remove setting up out of it. And then they added this exclusion clause for construction. Kindly see the definition now after 1/4/2011, which is there in the certified appeal also. That is at page, the impugned order.
Page 79.
Yes, at page 79. Oblige, my lord. Input service means the two clauses and includes services used in relation to only modernization. So the setting up is out. And that comes in the exclusion clause. And that is what the tribunal has interpreted it, that whenever construction or laying foundation is used as an exclusion in the input definition, that is for new construction. That is for setting up. Not when modernization, renovation, repair is involved. That is an existing plant. Mine is an existing plant. That is not denying it. And mine has been used for modernization, renovation, repair. That also is not denying it. I made the submission before the London Adjournment Authority. I told him kindly verify it. It was not verified. You could have visited it and seen whether modernization has taken place, whether repair has taken place, whether I'm actually loading this. But they cite some contract orders and then the court. And the most important thing, my lord, even the contracts, kindly see the show cause notice. It is not a part of the right upon document. He conjures up a contract and then cites it first time in the adjudication order. Kindly see the show cause notice, my lord. It is never cited. The show cause notice is Annexer A, which is the calculation of duty only. At page 25 or at page 19, which of all the show cause notices, the only annexer to it is the calculation of duty. None of these contracts have been relied upon documents. So first to rebut my argument, the first and the commissioner himself brings out a contract order and says that, look, this is for laying the foundation. But that would have been best done when I requested him to verify it, visit my premises, send an inspector or superintendent to visit my premises and verify. That was not done. Now he cannot say that it was not for modernization, it's not for renovation, not for repair. It was for one of these, all these purposes. And the board circle is very clear on this, that I'm covered by it. And the judgment also is very clear that I'm covered by it. So, this is not a case where any substantial question of law is involved. It is basically a precision of facts which have been accepted by the tribunal, and tribunal being the last fact-finding authority, this cannot be raised at this level. In fact, in this case also, the Honorable Supreme Court had an occasion to examine this issue. I'll just cite that also, my lords. My lords, under the appeal in this case has been filed under Section 35G of the Sentences Act. Correspondingly, there's a provision under the Customs Act also. Now, this is the second appeal. The second appeal is before the Honorable High Court in matters which do not relate to rate of duty or valuation. Now, if it relates to rate of duty or valuation, the second appeal is to the Supreme Court. That is 130E in the Customs Act. Now, in that context, the Honorable Supreme Court had an opportunity to examine when should these courts in the second appeal intervene. That is, kindly see the judgment at page 103 of my compilation, my lords. See, this was Honorable Supreme Court, Commissioner of Customs versus ASU Exim Private Limited. Let's kindly straight away come to para 9 on page 104. This was an appeal under section 130B against the tribunal decision because valuation was involved against the tribunal decision. This was the second appeal, para 9. They've cited from in Steel Authority of India versus Designated Authority. Civil appeal number so-and-so decided this court. The scope of appeal under section 130EB, which is the second appeal of Customs Act, has been dealt with in detail. It has been held that the following conditions must be satisfied to exercise jurisdiction under section 130EB. The question raised of arising must have a direct or proximate nexus to the question of determination of the application of rate of duty. That is because second appeal comes in. 2, the question raised must involve a substantial question of law which has not been answered or on which there is a conflict of decision necessitating a resolution. 3, if the tribunal, on consideration of the material and relevant facts, has arrived at a conclusion which is possible conclusion, the same must be allowed to rest, even if this court is inclined to take another view on the matter. In second appeal, it is not required to reassess the evidence, to re-examine the evidence all over again. If the tribunal has gone into the facts, has gone into the legal position, just because the appellate authority has a reason to believe that there's another view possible, that should not substitute it. That is what the Honorable Supreme Court has said in matters relating to second appeal. So, the short matter is, this is not a case where a substantial question of law is involved. This is just a matter of appreciation of facts, which the Honorable Tribunal has appreciated it and come to a definite conclusion that in matters relating to modernization, renovation, repair, the input service, whatever the service be, is available, and the exclusion is only relating to new construction, new cases, not those cases. And my learned friends have not given any contrary decisions of any court or tribunal holding another view otherwise. So, this is a fit case for dismissing the appeal at this stage. Malats.
My lord, I start with this particular judgment itself. My lord will kindly see.
But the fact remains that you have not disputed. The argument that the tribunal went wrong in saying that the revenue does not dispute. It is correct. What the tribunal has said is correct, because your show cause notice was on a different premise. I think the department representative thought to become wiser when he started arguing the matter. That is why the tribunal says show cause notice is entirely different. And that fellow was under the presumption that everything got excluded.
Yes.
Wrong understanding of law. Of course, at that time, there was a lot of confusion.
Yes.
After that negative list, etc., exclusion.
My lord, may I?
State of litigation. In fact, this paved way for a lot of books also to be published.
Yes.
My lord, may I invite my lord to the provision ones
Hmm.
from the book.
Central Excise Act.
Senvat credit rules, my lord. Eight of them, eight.
No, so bare act. I don't think.
No, the Senvat credit rules is there.
Eh. नहीं but Senate credit rules which period? आपका कब का है? Which period is this?
तो कोথায় আছে? My lord, may I invite, my lord? My lord, my lord, may I just place that portion again?
Rule?
The rule 2. Rule 2(1).
L.
Rule 2L. 2L. Rule 2L 1. My lord, I'll skip Roman 1, 2, 3 for a moment, my lord. My lord, may I give one more? My lord, rule 2L input service. Is my lord there with me? Input service means services provided or agreed to be provided by a person located in non-taxable territory to a person located in non-taxable territory by way of transportation of goods by a vessel from a place outside India up to the customs station of clearance in India where service tax is paid.
To LX.
No. Yes. Yes, input service. Okay.
ये कब का है? ये latest. I mean, is it to the relevant period?
Yes, it is relevant period. It is relevant. My lord, this has come. My lord will kindly see. It is applicable from 1st April 2011. My lord is there with me. It is applicable from 1st April 2011. May I place this now? Input service means services provided or agreed to be provided by a person located in non-taxable territory to a person located in non-taxable territory by way of transportation of goods by a vessel from a place outside India up to the customs station of clearance in India where service tax is paid by the manufacturer or the provider of output service being importer of goods as the person liable for paying service tax for the said taxable services and the said imported goods are his inputs or capital.
Wrong with it. Something wrong. I think there's a misprint or something. This is
My lord has the same thing.
provision. The provision has been reproduced in the impugned order, my lord. The whole provision is reproduced. The definition.
I'm reading from the book, my lord. Does that book also have the same thing, my lord?
Let us go by the definition in the
order.
The order. That is
Should we
correct.
go by the definition of the order or the different
That was not
publications
your
of-
ground, sir. Then that was a mistake means we should have.
So,
Yeah,
my lord, for a moment, let us leave that. My lord comes to exclusion and inclusion. My lord, and includes services used in relation to modernization, renovation or repairs of a factory premises or provider. There is no difference. It is the same thing. This is the section that is being quoted.
We have got your original point.
And includes services used in relation to modernization, renovation or repairs of a factory, premises of provider of output service or an office relating to such factory or premises, advertisement or sales promotion, etc., etc. And outward transportation up to the places of removal, but excludes. Now, my lord will kindly see what excludes. A. Service portion in the execution of a works contract. So the service portion in the execution of a works contract is excluded and construction services is excluded, including service listed under clause B of the
Section 66E of the Finance Act, hereafter referred as specified services insofar as they are used for A, construction or execution of works contract of a building or a civil structure or a part thereof. B, laying of foundation of making of structures for support of capital goods, except for the provision of one or more of the specified services, etc. So it is very clear that these are the exclusions. These are if there are services in the works contract, these are the exclusions. So now, my lord, will kindly see the show cause notice once. In this slide, my lord will kindly see page 19 once, page 17, page 17. The first paragraph at page 17. Whereas it appears Mrs. Balaji and Industries, holder of central excise number so and so, a manufacturing unit of iron and steel products of different grades and varieties falling under chapter number 72 of the first schedule to the Central Excise Act 85. So he is registered as this, my lord, as amended. Hereinafter referred to as the said goods have contravened the provisions of Rule 2.1, 2L and 3 of Senvat Credit Rules 2004 by availing credit of service tax paid on services rendered by their client, namely work contract services used for construction of structural support and laying of foundation for capital goods as input service. We are maintaining this only, we have not changed our tag. At no point of time have we changed our tag, nor have we built up a separate case after this. This was the show cause notice. This is what I am saying even now. The order in original also went on this basis. The tribunal went on a completely different tangent. Tribunal does not.
Same show cause notice signed the para 2.3. What is the final allegation they're making? Para 2.3, which I read out. Those are the facts here that read out.
May I finish?
What is? No, I'm just you're just selectively you're quoting.
I am
Yes,
I am in the
please.
first page only.
Please.
Yes, please proceed.
Page. So it's not that I have not said at the beginning, my show cause notice is on this, my lord. Now again, my lord comes back to what the tribunal has said. Tribunal has merely I will place both the tribunal's last paragraph again and the circular also. My lord will kindly see page 85, para 16. My lord, he notes the submissions of both the parties. He gives the definitions, and he gives the definitions of the first part only, pre-April 2011. That is the difficulty that my lord just now faced. He merely goes into that, where the biggest chunk of it was post-April 2011.
No, whole thing is post 2011. Actually, whole case.
So
2011.
So the definition that was being looked into was pre-2011. My lord.
All right, we'll consider.
No, my lord will also see. He comes to a finding that this is modernization. I have never said this is modernization. And when he said verify, from his own documents that he had given before the adjudicating authority, it was verified and it was seen that this is not modernization.
This appeal by the revenue filed under section 35 capital G of the Central Excise Act 1944 within bracket the Act questions the correctness of the final order dated 4th August 2022 passed by the Customs Excise and Service Tax Appellate Tribunal, Kolkata within bracket tribunal in Excise Appeal number 76215 of 2016. The revenue has raised the following substantial questions of law for consideration. Page number 12 of the memorandum, there are totally 4 questions, sir, 1 to 4. We have heard some. Though elaborate submissions have been made by the revenue, drawing our attention to various factual details. The issue involved in the instant case is to first ascertain as to whether any substantial question of law arises for consideration. At this juncture, it will be worthwhile to refer to the decision of the Honorable Supreme Court in Commission of Customs 1 versus ASU Exim Private Limited, page 103 of the compilation. The said case before the Honorable Supreme Court was an appeal under section 130 capital E within brackets small b of the Customs Act 1962, seeking to assail the correctness of the tribunal in relation to classification / rate of duty. In terms of the said provision, an appeal as against an order passed by the tribunal where the issue relates to the rate of duty or the classification of product, lies to the Honorable Supreme Court and not to the High Court. Nevertheless, the ratio laid down in the decision of the Honorable Supreme Court is of assumes importance in the case on hand. In paragraph 9 of the said judgment, it has been held as follows. Page number 104, please quote para 9.
Judgment, Supreme Court judgment.
Subpara 2I's and 3I's of para 9 of the above decision in the case of Steel Authority of India will be applicable to the cases before the High Court. The appeal presently filed by the Revenue under section 35 capital G is also identically worded, and what is required to be seen by this court is whether as to whether the question raised involves a substantial question of law which has not been answered or on which there is a conflict of decisions necessitating a resolution. The second aspect is that when the tribunal, on consideration of the material and relevant facts, had arrived at a conclusion, which is a possible conclusion, the same must be allowed to rest, even if the court is inclined to take another view of the matter. Bearing the above legal principle in mind, we propose to examine the case on hand. Firstly, we take note of the submissions of Mr. Kundalia that the tribunal committed a serious error in holding that it has not been denied by the department that the coke oven plant of the appellant was towards modernization and renovation of their existing plant / factory. It is a submission of the Senior Standing Counsel. This finding is erroneous, and in this regard has elaborately drawn our reference to the 3 show cause notices issued on the SSC, the first of which is dated 4/3/2014, for the period from 2011-12 to 2012-13 within bracket up to October 2013. The learned Standing Counsel has referred to.
There is a corrigendum, it will be 13-14. There's a corrigendum after that.
Sorry,
that page 21.
You strike it out for a period from 2011-12 to 2013-14 within bracket up to 2013. The learned Standing Counsel has referred to the preamble of the show cause notice. But as rightly pointed out by the learned advocate appearing for the respondent SSC, para 2.3 of the show cause notice is relevant, which is quoted here and below. Page 19 of the stay application, please quote para 2.3. To say the least, the assessing officer brushed aside the statutory provision, rather on a wrong understanding of the statutory provision has worded the show cause notice. The observation of the assessing officer stating that in terms of provisions of rule 2 within bracket L, services provided under works contract service have been straightaway excluded from the ambit of input service, and hence it appears that availment of such credit is not at all admissible. This conclusion at the very threshold by the assessing officer is on a wrong noting of the provision, or in other words, a wrong understanding of the statutory provision. Be that as it may, the assessee had submitted their reply and the case was adjudicated. Interestingly, when the case was adjudicated, the scope of adjudication took a different turn, and the assessing officer has gone into certain documents to come to a conclusion, to arrive at a conclusion with regard to the scope of work. In fact, such a finding rendered by the adjudicating authority was clearly beyond the allegation in the show cause notice, because there has been no annexures to the show cause notice except the computation of the alleged excess availment of SENVAT credit. Thus, the initial mistake committed by the assessing officer while issuing the show cause notice has perpetuated in an order of adjudication, carrying the mistake along with it. Thus, considering this fact, the tribunal, in our view, rightly held that the revenue has not denied that the coke oven plant of the appellants was towards modernization and renovation of the existing plant/factory. If such is the case, the claim of the assessee would clearly fall within the definition which of input services as defined under section 2 within bracket L, which was prevalent for the period from 1/4/2011 to 30/6/2017. The learned senior standing counsel took great pains to
2012 instead of
No, full period.
Pains to distinguish the decisions relied on, referred to by the learned tribunal. In our view, the decision, the manner in which the decision has to be read, it has to be read as a whole to enable the court to cull out as to what is the ratio decidendi. This is the cardinal and basic principle of culling out the legal principle in any decision. In the case of Reliance, Reliance Industries, which was referred to by the tribunal, it has been held as follows. Please come to page 47 of the compilation, para 4.10. To page 48. The above, on a reading of the above paragraph, it will clearly show that the decision can be squarely applied to the facts and circumstances of the case. In the said decision, it has been held, even though service of construction of building or civil structure or civil structure are falling under the exclusion clause, but even if similar service is used for renovation and modernization of existing factory, the credit is admissible. Full stop. The exclusion applies only in respect of such services as specified therein, which are used for initial setting of the factory. Thus, it is nobody's case, much less the revenue's case, that the project project undertaken by the assessee was one of renovation and repairs. One of modernization and renovation. This is precisely the reason the show cause notice was worded so by the assessing officer, though by wrongly interpreting the scope of Rule 2L. Thus, we find that the tribunal on reappreciation of the factual position has rendered a finding in favor of the assessee, which we find does not suffer from any perversity or for us to interfere in this second appeal. For the above reasons, we are of the clear view that no substantial question of law arises for consideration in this appeal. Accordingly, appeal fails, dismissed.
Much obliged. Greatly obliged.